Miss, bless your ladyship.
Yes.
I want to move in unlisted urgent matter.
What is the urgency? What is it?
There is a very urgency involved that I want to modify the order dated 31/7/2025.
IA, you're filing
Yes,
IA.
yes, which was passed by this court on 31/7/2025, and WBC 138.
Okay, you can move it tomorrow.
I don't know,
listed
because
item.
counseling is going on today, and one
Oh,
college,
acha, acha, that case.
and one college. Last date of admission is 4th August.
Okay, okay. Call for the file.
Much obliged.
Please, Your Lordship. Lordship, I would like to mention item number 16 and 17, my Lord.
16
Lord, here I've been informed by my clients that some talks are going on to settle this matter outside the court. So if this matter can come up after 2 weeks.
Learned counsel for the petitioner, Ms. Lucino, who submits that some talks are going on for an amicable settlement outside the court, and accordingly she prays for 2 weeks' time. So, learned additional regime and Ms. Vishukri is present for the state respondents, at least after 2 weeks.
There's an interim, my Lord, if
The
it can be
interim order
extended.
passed earlier shall continue till the next date.
Obliged.
Yes.
Yes, Your Lordship. Lordship, I beg to mention item number 18.
18.
Yes, Lordship. Hearing item 18, Lordship. On behalf of Livika, Lordship. If this matter can be fixed on Thursday, Lordship, I have taken the consent.
Thursday,
Yes, Lordship.
that would be 7th.
7, Lordship.
Learned Government Advocate MS Arinsa submits on behalf of MS Livika, who has some difficulties today, to list the matter on 7th August for hearing. Stop. Learned Counsel for the petitioner, Ms. Mika IA is present and has no objection. List on 7th.
Obliged, Lordship.
Yes.
Obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 22.
22. Yes.
Your Lordship, kindly grant us 3 weeks' time to file our reply.
To file.
Reply.
Reply.
Affidavit in reply. Yes, Your Lordship.
Learned Counsel for the petitioner, MS
Loreno.
Loreno, prays for 3
weeks' time.
weeks' time to file a reply to the counter affidavit filed by the Union of India. Stop. Prayer is allowed. List after 3 weeks.
Obliged, Your Lordship.
May it please your ladyship, I would like to mention item 9. Your ladyship, let this matter will come up after 1 week,
After
if my
one-
friend agrees. I'm yet to receive the instruction whether payment was been made or not. It's a less drawn error.
Okay, that let's draw.
Yes, yes, yes.
Why is it taking so long? I think regarding certain divisions, it has already been paid. Isn't
Yes,
it?
except for divisions.
And then only some divisions.
Because
are
one
left.
small problem is that we have to identify the persons, pay them like that. That small nitty-gritty things is there. That is why only
1 week.
1 week.
Learned Counsel Noah Imchen appearing for respondent number
5, 6, and 7.
5, 6, and 7, placed for 1 week's time to receive further instructions regarding the payments made to the petitioners. Stop. Learned Counsel for the petitioner, Mr. S. Wali, is present. List the matter after 1 week.
Obliged.
May I please, my ladyship, I beg to mention item number 6.
Yes.
Here the matter is under examination. So I pray that 3 weeks' time may be granted to me.
For respondent 2 to 5,
Yes, I'm for respondent number 2 to 5.
petitioner.
Oh, he's in court 1. He's in court 1. Petitioner
Have
is
you
in.
taken his consent?
Yes, I've informed him.
Learned Counsel V. Shukri appearing for respondents number 2 to 5 has prayed for
3 weeks'
3
time.
weeks' time to receive further instructions. Learned Counsel for the petitioner, and it is submitted that she has obtained the consent of the Learned Counsel for the petitioner. So accordingly, this is the matter of the 3 weeks.
Okay, much obliged. Again, my ladyship, I beg to mention item number 8.
Yes.
Here the petitioner was directed to produce her documents, but till now she has not produced her document, for which we could not comply the court's direction. So
What documents?
her educational qualifications, her appointment order
This is regarding
for
regularization.
yes, for regularization. Yes.
Yes, why you're not
No,
submitting?
Lordship, I will inform the client to submit the documents.
Then after 3
So
weeks?
after 4 weeks.
4 weeks, okay. Learned Counsel for the respondents, Ms. V. Shukri, submits that the respondents cannot process the case of the petitioner as she is yet to submit her educational documents. No, it just says documents,
Okay.
her documents. Stop. Learned Counsel for the petitioner is present. Stop list after 4 weeks.
Much obliged.
Obliged.
Your Lordship, I'd like to mention item number 2 and 3. Your Lordship, inadvertently, this matter has been posted for today. However, it was fixed for 11th of this month as per the last order as well.
Is it 11th?
Yes, my Lord. And also, I'd like to say that Senior Counsel.
Milots, I am appearing on behalf of ED in this. Milots, my learned friend is right. The matters were posted for 11th of August as per the last order. Milots,
Yes.
may have the last order.
Hello.
It says that if 90% is the consent. This is, may I just
तुम वो वाला देख कर हाँ
Sir,
हाँ देख कर आ जाना
there is, just your lordship will open that in a second.
And Your Lordship, also, since Senior Counsel Diganta Das is appearing in this matter, and his mother-in-law is my Lord. So we are requesting that instead of 11th, the matter be posted for 13th.
Yes.
Let it come on 11th because there is already a judicial order.
There is a difficulty.
We
are
can
not
mention
taking-
it. We can mention it on 11th.
I mean,
On
we're
11th,
not asking
on-
for much time, just 2 days. Instead of 11th, we can keep it for 13th, if there's not a problem.
See, Learned Counsel, there is already an order saying 11th. So on 11th, you mention it, okay? On 11th, you mention
My Lord, if both
Which
the
is what
parties are
I'm
here,
saying.
my Lord, and if we decided accordingly, because there he won't be, there is some ritual that he has to follow, my Lord.
No,
So
anybody
instead-
can appear. You can also appear. Anybody can appear and
I am
sit
not opposing the request, Mr.
Yeah.
Amit. All I'm saying there is already a judicial order. Let it come on 11th, then we will
No
mention.
problem. No problem. We can do that.
Learned Counsel and such appearing for the petitioner, petitioner / revisionist. Stop. it is stated that this, by an order dated 28/7/2025, this matter was directed to be listed on 11th August 2025. However, the matter has been wrongly listed. So the Learned Counsel for the Directorate of Enforcement has also agreed with the same. Accordingly, list the matter on 11th August 2025. Yes. Learned Counsel for, you are appearing for?
Much obliged. So, my lords, I'm appearing for respondent ED.
No, yours.
I'm appealing for the petitioner, my lords.
Okay, yes.
Obliged.
11th.
Much obliged.
May I please, my lord?
Obliged.
Yes.
May I please, my lord?
Yes. Okay, yes, KM Dummy.
I beg to mention item number 13, my lord. I am for the respondent number 1 here. I'm yet to
13.
receive. Yes, my lord. If 3 weeks' time can kindly be granted, my lord.
Learned Counsel, Mr. N. Angami, Learned Senior Government Advocate, Mr. N. Angami, prays for 3 weeks.
Yes, my lord.
3 weeks' time to file affidavit in opposition on behalf of respondents.
1.
Respondent number 1. Learned
My lord,
Counsel, yes.
I'm appearing for respondent 2, 3, and 4. And then on the last occasion, we have prayed for to reflect my name. But this time also it is not reflected. So
is not
kindly
reflected.
reflect my name in the cause list.
Okay, Learned Counsel, Mr. Temjin.
Yes, Timjan.
S. Temjin submits that he has received instructions to appear on behalf of
2, 3, and 4.
respondent number 2, 3, and 4. However, his name has not been reflected in the cause list. Stop. Learned Counsel for the petitioner is present and has no objections. Raise the matter after 3 weeks. Stop. The registry is directed to reflect the name of Mr. S. Temjin as counsel for respondent number 2, 3, and 4.
My lord, I on behalf of counsel for petitioner Anunda Elkir.
Yes.
My lord, respondent number 1, the chief secretary, is retired. My lord, I may be allowed to file petition by implementing the new incumbent chief secretary.
Learned Counsel for the petitioner, MS Anunda, has submitted that the respondent number 1 has retired and she prays for permission to implement the new incumbent as respondent number
1.
No, he will be
4.
respondent number 5.
5.
As respondent number 5. Stop. Prayers allowed. The petitioner shall file an IA. You have to file an IA for amendment of the same. Yes.
Much obliged.
Please, Your Lordship.
Yes.
I beg to mention item number 4.
4.
Item number 4, yes.
Yes, what happened?
Lordship, here there is a slight error in my petition. And
There is what?
Slight error in my petition, therefore pray for withdrawal of
You want to withdraw?
petition, yes. And file any petition.
Item 4. Learned Counsel for the petitioner, Mr. such and such, submits that there is some inadvertent mistakes in the petition and he would like to withdraw the same. Stop. Accordingly, Learned Counsel is allowed to withdraw the petition with liberty to file afresh. Disposed of as withdrawn.
Yes, Your Lordship.
Yes.
I beg to mention hearing item number 19. We have the consent from the other parties. So kindly let the matter be listed after 3 weeks.
3 weeks.
Yes.
Learned Counsel, MS such and such, appearing for the petitioner. You are appearing for the petitioner and prays for 3 weeks time. She has submitted that the consent of the other parties have been obtained. Accordingly, list after 3 weeks. Yes.
If I may be allowed to make a mention for listing of a case tomorrow. This matter was supposed to be listed today, but it was not reflected in the cost list. If it can be
Order is already there for listing today. Earlier order. Okay. It's tomorrow.
I'm led by a senior counsel who has already reached Kohima. I'm outside. Obliged.
August Lordship. I beg to mention item number 10.
10.
Here, Your Honor, respondent number 5 is no longer holding the post, so I may be allowed to file an IA for implement of the new incumbent, that is the Financial Commissioner.
Respondent number
5.
Learned Counsel, Mr. S. Wali, for the petitioner, submits that respondent number 5 has been transferred out from the post, and accordingly he would like to implement the new incumbent. the prayer is allowed, the petitioner shall file an IA for amendment of the same.
Obligation.
May I please, Lordship? My Lord, I beg to mention item number 12. My Lord, here I'm appearing for response number 4 and 5. My Lord, I've received instruction that response number 5 or 3 has instructed AG to file appeal, my Lord, in this case.
Instructed AG to? No, but unless there is some stay or something in the appeal, unless
Yes,
there
my
is an order, what is that? What is this got to do with the contempt?
So, my Lord, let the matter be come up after 4 weeks, my Lord.
This is what, payment of skill pay? Skill pay or
Yes,
what?
yes, my Lord.
But isn't there a notification of the
No, that latest notification is
2025?
that is only in regard to fixed pay, those who are enjoying fixed pay. But here the petitioner is enjoying already scale pay. So that new office memorandum is not covering his case.
In fact, Your Ladyship,
Yes.
there was a communication made by the department to the counsel for respondent number 4 and 5. It is letter dated 27 of March 2025, which was also produced before this lower court. This says that the case of the petitioner is covered by the office memorandum and his case will be considered. And basing on this communication,
Yes.
the respondents, they were seeking time.
Yes, what happened? 27 March?
Yes, my Lord,
That
yes.
communication is already there,
Yes,
saying that his case was covered by the memorandum.
yes, my Lord. But when I placed this letter, but in the office memorandum, your Lordship may kindly see the next page in the office memorandum. It says that it is covered only to the employee who are enjoying fixed pay.
No, what was the direction of the court?
To grant the scale of pay in terms of the lattice ROP. The lattice ROP is 2017.
That is different, ROP
Yes.
is different.
Yes, my Lord.
Because
Yes.
that
My Lord,
2025
Yes, my Lord, that
refers to ROP of 2015.
2017 ROP is not applicable to his case because in that 2017 ROP, only the regulars are,
Regular stuff.
yes.
But when
So
the
that-
court's
so-
order is already there,
Yes,
and you had not
exactly.
filed an appeal,
Yes, that is why now only they are giving instruction to file appeal to the AG. my
after
Lord.
contempt is filed, that is. you
And the
have
contempt has been
suddenly
pending for some
woken up,
time.
and the contempt is of 2024.
Yes.
No, this will not help you unless you can produce a copy of the order passed by the appellate court. This will not do, just a letter will not do. If you are seeking time to file affidavit, that's a different thing. Learned Counsel Mr. Tibapong, on behalf of respondent number 4 and 5, who has prayed for a month's time to receive instructions. Let's see. Learned
Yes.
Counsel for the petitioner is present. I'm not saying anything about
Okay,
the
ma'am. Okay.
list of the 4 weeks.
Much obliged.
Turn this.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 20, Lordship.
20.
Lordship, the principal counsel is indisposed. Let it come out after a week, Lordship.
Counsel for
The respondent, Lordship, sole respondent.
sole respondent.
Lordship.
Learned Counsel Mr. C.T. Rongsum, who for the respondent, for the sole respondent, who submits that the leading counsel Mr. Lui Kam is indisposed and accordingly prays for
1 week.
1 week's time. Learned Counsel, no objection.
I've not.
Learned Counsel for the petitioner, Ms. is present and there's no objection. List after 1 week.
DP objections.
For motion, item number 1. Wait, please, my lord.
Yes.
This is a POCSO matter, Lordship. The
Against conviction.
Lordship, yes. The petitioner is the brother of the accused person. He is duly authorized to file this revision petition, and herein he is assailing, challenging the impugned judgment and order by which the accused person has been convicted and for 3 years under Section 8 of the POCSO as well as 354A1 of the IPC. And amongst others, Lordship, the grounds on which this revision petition assailing the perversity and illegality of this, the learned special judge, POCSO Kohima, is one of them being that under Section 42 of the POCSO Act, Lordship knows that there is an embargo. The court is to impose a punishment which is only greater in degree. Person, yes, Lordship. Therefore, however, in this case, my lord, yes. So here, the accused person has been punished to undergo a period of 1 year rigorous imprisonment under 354.
Where is the judgment?
Lordship, it starts at page number 16 of my petition, Annexure C, and the operative portion will be at page number 38 of the order. I'm sorry, 39, para 7 more particularly.
Page 39.
Yes, Lordship. Page 39, para 7. Lordship, permit me to read. This is the order after quantum was heard. Accordingly, accused Ajubi RK is hereby sentenced to undergo simple imprisonment of 3 years for the offence under Section 8 of POCSO and to pay a fine of ₹1,000 and in default of payment of fine to undergo simple imprisonment for 2 months. Lordship, para 8, for the offence of 354A, the accused is sentenced to undergo 1 year rigorous imprisonment. Both sentences shall run concurrently. So, the learned special judge
Correct, Learned Counsel for the petitioner, Mr. Ali Zokiri. The present revision is preferred against the present revision. You have come under which provision?
Lordship, it is at under 438.
Section, 438, read with section 442 of the BNSS, praying for quashing and setting aside of the judgment dated 5/6/2025, passed in GR number 75/2021 in connection with Women PS Kohima case number 09/2021. Stop. The petitioner has challenged the said, has assailed the said impugned judgment and order on the ground of illegality due to non-compliance of Section 42 of the POCSO Act 2012. Any other grounds?
Lordship, yes. Another ground that I'm taking is that a document, Lordship knows, is not merely proved because it is merely exhibited and adduced as an evidence. The content has to be proved, Lordship. And this argument was also taken before the learned special judge at the time of argument. However,
when also on the ground that a document is not proved merely because they are exhibited.
Lordship, the minority of the victim was not established. That is the gist.
I.e., the document by which the minority of the victim was to be proved. Stop. However, the prosecution has not proved the said document. Stop. Who accepts notice? Mr. K. Angami, Leonard PP, has accepted notice on behalf of respondent number 1, the state of Nagaland, and hence no formal notice is called for. Learned counsel for the petitioner shall take steps for notice on respondent number 2.
Lordship, if I may.
Yes.
The matter being a sexual offence in nature, I have impleaded the informant, who is the mother of the victim, the complainant.
Yes.
But, Your Honour, even as per the LCR, the address which has been used to correspond is an address which is inadequate. And also, here the case is such that the alleged accused person and the victim, they reside adjacent to each other. And the accused person's wife is still residing there at AG Colony, Kohima. And I am informed that it has been some years since they've left. And therefore...
Oh, they've left that place?
Lordship, yes.
Because normally in POCSO cases, the notice on the victim or the informant is served through the concerned PS, concerned police station. So that means if they are not there anymore...
Yes, the wife is still there, so I have information. Last week only I am informed that it has been some years rather since they have shifted to another locality or town. And therefore...
They are no more in Kohima. Because if they are in Kohima, the police can trace them out.
Lordship, that is not in my knowledge, but...
Then we will just take one thing. Yeah, and then let's see. Serve on respondent, what did I say? Respondent number 2 shall take steps for service on respondent number 2 through the concerned police station, which will be routed through the office of the public prosecutor. You have to take the steps through the office of the public prosecutor, Gauhati High Court, Kohima bench. Notice is issued returnable within 1 week, 4 weeks. Stop. Call for the trial court records from the court of the Learned Special Judge POCSO Act, Kohima. Yes.
I'm obliged, Lordship.
For motion, item number 5.
Please, Lordship.
Yes.
Lordship, this instant I is filed for impleadment of respondent number 3, the Home Commissioner, Shri Anup Kinji IS, since the respondent number 1, Shri Vyasan R IS, who was the Home Commissioner, has been transferred. So if the Lordship may be pleased to allow to implead Shri Anup Kinji as respondent number 3 in the contempt petition.
Counsel for the petitioner and Ms. Such and such. This application under Order 1, Rule 10.2 of the CPC has been filed praying for impleadment of Shri Anup Kinji, IAS, the Home Commissioner Nagaland, as respondent number 3. Stop. Learned counsel for the petitioner states that during the pendency of the civil original contempt petition number 3 of 2025, the respondent number 1 has been transferred out from the Home Department in the month of June 2025. Stop. Thereafter, Shri Anup Kinji IS has taken charge as the new Home Commissioner Nagaland, Kohima. Stop. And by this court's order dated 21/7/2025, the petitioner has been allowed to take necessary steps to implead the newly appointed incumbent. Stop. Hence, this application has been filed, praying for impleadment of Shri Anup Kinji IS, Home Commissioner, as respondent number 3. Stop. Para. In view of the fact that the respondent number 3 has been transferred out, comma, the prayer of the applicant is allowed, stop. The petitioner is allowed to take steps to file the amended cause title, including Sri Anup Kinchi IS Home Commissioner as respondent number 3 in the civil original contempt petition number 3 of 2025. Stop. The petition is disposed.
For admission, item number 7.
Yes.
Please, Your Lordship.
Yes.
My Lord, this criminal petition is filed, Your Lordship, impugning the order dated 24/5/2022. Your Lordship, at the outset, Your Lordship, I beg to place a small hints on the cases. Your Lordship, the petitioners are residing in Jharkhand, as well as the accused are also a resident of Jharkhand. Now, Your Lordship, there was a business dispute between the petitioners and the accused petitioners and between the complainant, father-in-law. And there was a litigation pending before the Jharkhand court, Your Lordship. Now, all of a sudden, the complainant, she has come to Dimapur and filed a complaint. First, she approached the Suburban Police Station, Dimapur, Nagaland, Your Lordship.
Yes.
Suburban Police Station, Dimapur, Nagaland refused to accept the case because the cause of action arose in Jharkhand, which is 1200 kilometers far from Dimapur. Now, thereafter, Your Lordship, this complainant, she has approached the Honorable Court of Judicial Magistrate, Chief Judicial Magistrate, Dimapur, filing a CR. Now, in the CR, she has lodged her complaint that while she was in Jharkhand in her place, the accused person, who are her petitioners, they have burst into her house and they have assaulted her and taken away her money, all these things. Then this Honorable Court of Chief Judicial Magistrate, Dimapur, Nagaland, she has referred the matter to the police, to the women police station to investigate into the matter under section 190 of CRPC. Now, Your Lordship, here my case is that all the actions attributed by the complainant as well as adjudicated by the Honorable Court are beyond jurisdiction. This is my case only, Your Lordship. Now, Your Lordship, I beg to take Your Lordship at the first instance to that impugn order.
But the complainant lives in Dimapur.
Yes, Your Lordship.
Complainant is a resident of Dimapur.
No. She is a resident of Jharkhand, Your Lordship. I beg to take Your Lordship to our complaint petition first, then Your Lordship will. That Annexure 2, page 24. Then Your Lordship will have a glimpse on that.
Yes.
Yes. Your Lordship, page 25.
Page 25.
A complaint under section 200 and 156(3) of the CRPC 1973, praying to take cognizance for the commission of offence by the accused person under section 499, 380, 356, 503 and 319 of IPC and punishable under section 500, 379B, 506, 323 of IPC. Now, these are theft, then assault and all this, Your Lordship. There the complainant is a citizen of India and is a resident of the above mentioned address, which is within the jurisdiction of this Honorable Court. There the humble complainant is a housewife born and brought up from Dimapur and a permanent resident of Dimapur. There the complainant after her marriage both Dimapur and Jharkhand, and when required without any fixed period. There the complainant and the accused persons were acquaintance of my husband for business-related matter. It will be her husband anyway. But however, they are no more associated with each other since 2018. Now, Your Lordship, the matter starts from here. That the complainant and the accused persons were acquaintance with her husband for business-related matter. That the brief story of the case is that on 22/03/22, while the complainant was at her father-in-law's place at Hazaribagh, Jharkhand, with her mother-in-law and her 18 months old son, at around 3 p.m., the accused persons abruptly burst into her house and, having the knowledge about the absence of her husband and father-in-law, started to take advantage of the situation. They started to charge the complainant in front of her mother-in-law and her innocent son, using means of violence, and intentionally assaulted her without her fault. Amidst all this, the accused Omidjoin took out a pistol and violently pointed on the complainant's head, pushed her on her mother-in-law and her innocent son, using means of violence, and intentionally assaulted her without her fault. Amidst all this, the accused Omidjoin took out a pistol and violently pointed on the complainant's head, pushed her, it is the repetition of the same matter, husband, and threatened to complain by asking the whereabouts of her husband and her father-in-law, and that he will harm her family's reputation everywhere by defaming her family. That both the accused person, knowing that complainant's native place is Nagaland, started to verbally abuse her by undermining and humiliating me, calling her people of Chinkiland. These are nothing, Your Lordship. These are just a ploy to make she is a Marwari, how she will be a Chinki, and told her that they have so many contact sources there in Dimapur and will ruin her reputation there in Dimapur also. That on the pretext of verbally abusing her, mention may be made that the accused person also stated Nagaland has no value whatsoever, and that ruining family's reputation will not be a problem for them. That the accused person not only indulged themselves in the act of committing abuse in physical and verbal form, but also intentionally, before leaving the house of the complainant, after creating such a havoc, snatched all the jewelries which she was wearing, consisting such and such, one gold chain and all this. Thereafter, they threatened her by saying that no one will know even if they harm her, because they have good connection everywhere. Now, Your Lordship, these are our basic complaint is that while she was in Jharkhand, that took place. Now, Your Lordship, I beg to take Your Lordship to this FIR, Your Lordship, by the police. Page 34, Your Lordship. Page 34. Dimapur Women Police.
Yes.
Now, serial number 5, Your Lordship. Serial number 5.
Place of occurrence.
Direction, place of occurrence and direction and distance from PS. 1276.5 km approximate east from Women Police Station.
But it can be at the place where the complainant resides also.
Now, Your Lordship, she is a resident of Jharkhand, Your Lordship.
Cause of action and then place of residence also.
Cause of action where arose, Your Lordship? Cause of action initially arose there, in Jharkhand. Why she has not taken the help of police in Jharkhand? Now they are coming with a plea under section 156, Your Lordship. 156(3) CRPC, it says that, Your Lordship, that if the police does not want to take any or refuse to take any complaint, then the complainant does have a right to lodge a complaint before the SP. He has a right to lodge a complaint before the SP or any other having jurisdiction, competent court having jurisdiction. Your Lordship,
I'm sorry to interrupt at this moment, Lordship. I'm for the
it is my turn. It is my turn.
I understand.
Let him.
Your Lordship.
There is just a small development.
Your Lordship.
I just want to point out, I'm so sorry, sir. I just want to point a small development. Actually, I have instructions from the client. Just a few minutes back, I got the instructions that they actually not seek to intend to pursue this matter anymore. So
then okay, Your Lordship.
that is the reason I'm very sorry.
Sorry. Thank you, my learned friend.
Yes, so Lordship, instead of wasting the valuable court's time, we can.
Much obliged, Your Lordship.
So instead of letting Mr. Paul
Lordship, just 2 minutes back, I got the instruction.
And
because
I am an old person, Your Lordship, on the verge of my retirement.
I'm so sorry for that. With all due respect, it was just a matter of time. I had to get the instructions in written form from the complainant. If I don't have, so, Lordship, then it will be difficult for me, Lordship. So.
Thank you, my learned colleague. Thank you.
Okay, in that case, you seek for some time then.
Lordship can fix a small date and I can withdraw the matter on that date.
Yes.
Yes, Lordship.
And that prayer may be reflected, Your Lordship.
Yes,
Of course. At the outset, the learned counsel for the respondent, Mr. Such and such.
M.K. Das, Lordship. M.K. Das. Respondent number 3, Lordship.
Respondent number 3, Mr. M.K. Das, has submitted that the complainant / respondent number 3 does not wish to pursue the matter anymore and has decided to withdraw the complaint. So accordingly, he prays for some time to receive further instructions and to place the same before this court on the next date.
Lordship.
Accordingly,
So this week, Your Lordship, on Friday.
Just check once.
Friday.
Lordship, if it
Yes,
comes
Your
in,
Lordship, Your Lordship, I am having some problem. I am also going out, Your Lordship, for my treatment in Bangalore. I am going. So this week on Friday.
8 August, yes. Learned counsel for the petition. Yes.
Hosiko is there, Your Lordship.
As well as learned BP. Yes.
My lady, if interim may be continued till next day.
Interim
Yes, ma'am.
we shall continue till the next date.
Highly obliged.
Deeply obliged. Highly obliged, Lordship.
Deeply obliged, Your Lordship.
For orders, item number 11.
Who's there for the appellate? You were permitted to take first steps.
Yes, sir. I've taken steps on 23rd of July 2025.
Learned counsel for the appellant, Mr. Moa Jamir, is present. On 17/7/2025, this court had permitted the appellant to take first steps for service of notice upon the sole respondent through the jurisdictional magistrate. Stop. Office note dated 28/7/2025 indicates that service of notice upon the sole respondent through the jurisdictional magistrate has been sent to the Principal District and Session Judge Tuing Sang. Right letter dated 28/7/2025, and thereafter service report is awaited. Accordingly, this is the matter after 3 weeks awaiting service report on respondent number 3. 3, isn't it? No,
the sole respondent.
On the sole respondent, not 3, on the sole respondent.
Obliged.
For orders, item number 14.
May I please, my lady, as per this honorable court, we have taken steps upon the respondents by way of registered posts. Your Honor, till date, except for this government,
What was the last order? When was the last order passed?
on 24/6.
24/6.
We're challenging the legality of the supplementary charge sheet. And this honorable court was pleased to stay the charge sheet in respect of the petitioner.
Learned counsel
And within the
for the
extent,
petitioner,
the-
Mr. Fosito, is present. Notice is not complete. Return service is awaited. Yes.
Let it come up 2 weeks then, Lord, my lady.
Learned counsel is inside.
Moreover, the state is supposed to file an affidavit. On the last date, they were saying that they filed the affidavit before the next date, but today,
Yes, who's appearing?
On the last
Three
petition,
respondents.
S. Mary was
Mary. Miss Mary.
S. Mary was appearing, but
Research.
Yes, Mary,
Office
the
note
prosecutor.
dated 24/6/2025 indicates that return service report on respondent number 8 is still awaited. Stop. The public prosecutor, Ms. S. Mary, has also not produced the scanned copy of the case diary, nor has she filed the objection/affidavit in opposition. Stop. Accordingly, list the matter after 2 weeks awaiting service of notice on respondent number 8. Stop. The learned PP shall also obtain the scanned copy of the case diary on the next date. Stop.
record was called for, but I don't know if, I think record is here, it seems.
Oh, report has come.
Record has come.
Okay, then got that case diary.
Yes.
The trial court records have been received. List after 2 weeks. No?
Your Honor, if my lady, if the interim can be continued till next date.
Interim order passed earlier shall continue till the next date.
I'll oblige, my lady.
Unlisted motion, item number 24.
Two more hearing. Yeah, this is that MBBS counseling one. What happened?
Me-
You have served
ladyship,
notice.
Before I say anything, let me take your ladyship to order. Since your ladyship is very much well aware of the things. Page
Yes.
18. Page 18.
18, yes.
Your ladyship, this is the order based on
That first read petition.
first order. I'll take you to paragraph 20.
Yes.
Page 18, paragraph 20. Thereby, the respondent authorities are directed to allow the petitioner to participate provisionally in the counseling, scheduled to be held on 30/7/2025. Now it has been, it is doing today.
Oh, today.
It is doing today. Authorities may also explore possibilities if one seat can be kept vacant without holding the process for others pending disposal of this writ petition. That was the operative bara of the order dated 28/7/2015. Now, let me take your ladyship to the page 28. Page 28.
Yes.
This is the order 31/7/2025 passed by your ladyship. Para 9. The entire counseling and selection process shall be subject to the outcome of this writ petition. As far as one seat in the central board is concerned, it is clarified herein that one seat which was directed to be explored and the order dated 28/7/2025 will be from the central board. So, your ladyship, this application under 151 of the CBC is to clarify this point. Now, your ladyship, for your understanding, I'll take you to to my petition, page. I'll read.
Yes, yes.
Page 3. From page 3, paragraph 1, I'll read. The opposite party number 1. The petitioner has filed the connected writ petition being WBC number 138 of 2025, which is still pending before this Honorable High Court. The fact stated in the writ petition is as under. The petitioner's father is serving as a colonel and posted as commanding officer of 1 Nagaland Battalion, NCC, Kohima, Nagaland since 2024, Your Lordship. Since 2024. The opposite party number 1, petitioner has alleged that she has scored 455 marks out of 720 marks in the National Eligibility Cum Entrance Test (NEET) undergraduate 2015-25 and applied for MBBS statement for the state of Nagaland for academic session 2025-26. It is stated that the provisional selected candidate list for the state of Nagaland has already been prepared and notified as per the existing state government notification guideline, and the name of the petitioner was not amongst the selected candidates. The opposite party number 1, the petitioner has alleged that she is eligible to be included in the provisional selected candidate list for the Nagaland State NEET UG 2025 for the academic session 2025-26 in the selected merit list under the central pool. B. The state government has issued a notification dated 9/9/2021, whereby the petitioner candidature does not fall under the paragraph 1 category 3B, 2C, and 3E, such as her name was not included in the provisional selected list. Number C. The opposite party number 1, the petitioner being aggrieved, filed WBC 134 of 2025, praying for quashing and setting aside of the selected list dated 24/7/2025 in respect of the MBBS set, and further to include the name of the opposite party number 1, petitioner to be included in the revised list of selected candidates. It may be mentioned herein that the aforementioned writ petition is also pending disposal before this Honorable High Court. D. The opposite party number 1, petitioner having not challenged the state notification dated 9/9/2021 in the writ petition number 134 of 2025. The opposite party number 1, petitioner has filed the connected state writ petition with a prayer to set aside and quash the clauses in paragraph 1, category 3B, 2C, and 3E at the said notification in respect of the MBBS UG says, and further to consider the case of the petitioner and include her name in the provisional selected candidates for Nagaland State NEET UG 2025 for academic session 2025-26 on the basis of the directions issued dated 9/12/1986 and similar directions issued by the Minister of Health and Family Welfare, Government of India, and be called for the cancellation to be held on 4 August 2025 by allocating a seat from the central pool. Central pool MBBS seat. Number 2, that the applicant simply stated WBC number 134 of 2025, which is pending disposal before this Honorable High Court. And this court has passed an interim order dated 28/7/2025, whereby it has directed the respondent application authority to allow the opposite party number 1 petitioner to participate professionally in the counseling scheduled to be held on 30. Now it is scheduled to today, 4/8/2025, and further to explore the possibilities if one seat can be kept vacant without holding the process for other during the pendency of the aforementioned petition. Copy is there, Your Ladyship. Number 3, the applicant simply submit that the scheduled counseling to be held on was postponed to today, that is 4/8/2025. The applicant simply submitted the updated provisional selected candidates for Nagaland State UG NEET 2025 for academic session 2025-26 has been notified to all the candidates. Annexure is there, Your Ladyship. That the applicant simply submitted during the pendency of the writ petition 34 of 2025. The opposite party number 1, petitioner has filed the writ petition number 138 of 2025. The Honorable Court, after hearing the parties, has passed an interim order 31/7/2025 by clarifying that one seat which was directed to be explored and order dated 28/7/2025 will be from Central Pool. Annexure is there, Your Ladyship. Number 6, that the applicant simply submit that with regard to the direction of the Honorable Court, passed above mentioned interim orders allowing opposite party number 1 to participate in the scheduled counseling, the applicants have no objection. However, with regard to keeping one post vacant from the Central Bowl MBBS seat before the disposal of the writ petition shall affect the selection process of other selected candidates. Your Ladyship, that is from the indigenous inhabitants of Nagaland and backward tribes. That is clause 1 and 2. Your Ladyship is well aware. Number 7, that the applicant simply state that the opposite party number 1, petitioner, while filing the writ petition 134 of 2025, has not challenged the notification dated 9/9/2011, and while the opposite number 1, petitioner, has impugned the notification dated 9/9/2021 and the connected writ petition 138 of 2025, which are put pending disposal before the Honorable High Court. It is pertinent to mention here that the name of the opposite party number 1 petitioner was not included in the selected list, as she failed to satisfy the eligibility criteria clause in paragraph 1, category 3B, so and so. Your Lordship is well aware of the said notification to be selected for Nagaland 2002 academic session sciences. Further, the name of the opposite party number 1 petitioner cannot be included in the selected candidate list until the notification dated 9/9/2021 is quashed and set aside or stayed, which was not done by this court. Your Ladyship, and WBC 138, the petitioner has challenged the validity of the notification dated 9/9/2021, but without staying the notification, we were directed to explore one seat from the central board. Number 8, Your Ladyship, the applicant humbly submits that in order to qualify for the Nagaland State NEET UGC 2025, a candidate should have appeared past class 10, 12, or equivalent from any schools within the Nagaland, and his parents should have been residing posted in Nagaland for at least 3 years or more. Both criteria should be fulfilled. It was not fulfilled, Your Ladyship. Number 9, that the applicant humbly submits that in the event of giving one seat vacant for considering the case of the opposite party number 1 petitioner, it may amount to deciding the case in favor of the opposite party number 1 petitioner without disposal of the writ petitions on merit. Now, Your Lordship, I may add one word here. We have not selected only the present petitioner, but 6 of them is there in the list who were not considered because they did not qualify the OM dated 9/9/2021, stipulated and category 3. Your Ladyship may please appreciate the list.
The category 3.
These are the 6.
I hope, my lord, the file is tagged with the main writ petition.
Yes,
because
yes, it's here.
the reference
Yes,
of the
it is there.
main writ
It is
petition
there
will be
also.
required.
It is there. Yes, 6
Yes,
of them were
for your Ladyship information, this year, the need for the Nagaland State, the qualifying marks was 113. So, Your Ladyship, kindly see all of them. All 6 of them has scored. Last one has scored 140. So, all 6 of them has secured the qualifying mark. Your Ladyship,
Yes.
page 8, para 10. That the applicant humbly submits that the admission process is starting from 8/8/2025. Now, in one college, Your Ladyship, I will remind you, Agartala Medical College, 8/8/2025 is the last date for admission. I have annexed that also. Copy of the notification dated such and such. As such, even if one seat is kept vacant, it shall affect the entire selection process, and further, it may also affect the rights of the selected candidates for the state of Nagaland. Annexure, Your Ladyship, you will find. Number 11, that the applicant humbly submits that the list of selected candidates was done as per the directions issued by the central government and in consonance with the state reservation policy, notification and guideline issued by the state government. Number 12, that the applicant humbly submit that the directions of the central government have acknowledged and the admission of candidates to various colleges will depend on the fulfilling of the criteria, conditions and of admission and other requirements as laid down by the concerned institution, state government. As such, the opposite party petitioner is not eligible as per the eligibility criteria, conditions of admission and other requirements as laid down by the state government. That is, Your Ladyship, 9/9/2021 notification. Number 13. That the applicant humbly submits that before filing of the writ petition, all states of the Nagaland state, UG, NIT UG, for the academic session 2025 to 26 has been allocated and notified to the qualified candidates on the basis of merit. If the interim order dated 31/7/2025 is allowed to stand and not interfered or modified with the entire selection process for the state of Nagaland will be adversely affected, and further the meritorious candidate from the state of Nagaland will be deprived of their rights and eligibility. And as such, without implementing the selected candidates, Your Lordship, the right of those candidates shall be adversely affected. Here, the selected candidate was not been implemented as a party respondent. That is one issue which has to be noted by Your Lordship. And then, Lordship, that is two paragraph,
So
number
your
14.
prayer is for cancellation, modification, alteration of the word central pool.
No.
So that means, no, in your prayer you have stated clarification, modification, alteration of the word central pool. Your prayer.
My prayer is yes.
But the other seats, she's not eligible. Only in the central pool they are claiming. Only against the 42 seats, isn't it? Not against the others, because others she cannot claim.
No. Your Lordship, I will satisfy Your Lordship.
Only in central pool, because of the central government the ministry directions, that's why they are claiming.
I will satisfy Your Lord, Your Ladyship.
See, actually, this type of cases is better to dispose it off, since there's urgency. Isn't it better to file
Your
your
Ladyship,
affidavit and hear it
this
one
year,
of these days? Yes.
Your Ladyship, this year we have selected 152 candidates. That includes the central poll also. I will give you the data. That is the thing, Your Ladyship. Central poll is 42.
Yes, exactly. Even in the petition it says 42, central pool.
And this is a distribution, 152. Total 152 seats.
Total is 152.
Yes.
And out of that, 42 is central pool.
Yes,
Isn't
it is
it?
already given.
Yes.
And this, everyone has been selected.
That is not disputed.
Actually, that is not correct, Lordship. In the central poll, only 2 persons out of the 6 candidates has obtained the marks who can be made eligible. The one who stood in the second and out of the 6 persons belonging to the children of central government employees. One is it's coming to 41, Cyril, considering the marks. Of course, it is the state respondents who can arrange, but from the marks secured in the NIT, the other candidate will come in serial number 41, but that candidate is not before this Honorable Court, so we are not bothered with that. So Lordship is burdened with only one candidate who secured in the second position, Lordship. And considering the submission of my learned friend.
No, have you completed?
Not
So
know
what
it
is your
Sorry.
prayer? You didn't exactly explain to the court what your prayer is.
My prayer, Your
Yes,
Ladyship,
it
is
says here for clarification, modification, alteration of the word central pool.
Central Poll already selected and it has already been notified. The list is there, Your Ladyship. Please appreciate that. Now, Central Poll 42 already selected, notified, and they are doing the counseling today. So how can we reserve one seat from the Central Poll? That is the issue.
Then in that case,
It is practically impossible for the
if
state.
we just modify it to the extent that it will be just that should be subject to the outcome that will remain, and then to explore the possibility.
It has become impossible to explore the possibilities. It has become impossible because candidates have already been selected and notified. The reason is, Your Ladyship, please appreciate notification dated 9/9/2021, Category 3. Category 3 is children of non-local state government employees. Your Ladyship is very well aware. So when they did not qualify this, how can they be considered for the Central Poll?
No, but they are challenging that, no? They are challenging that notification, that criteria.
They are challenging, but the petition has not been disposed, Your Ladyship.
Of course, it's not disposed. Yes. Okay, yes.
Yes, Lord. May I please, Your Lord?
Yes.
I believe my learned friend is not very clear with the concept what is meant by central poll. The other day I have been making submission what is central poll and to what extent the petitioner is claiming her right based on the Government of India notification. But at the time of passing the interim order, few documents have been placed by my learned friend where the director has written a letter by referring to a letter dated 12 August 2024, which pertains to last year, whereby a clause has been shown that the state may adopt
Yes.
the reservation policy being followed by the concerned beneficiary state will apply on central poll MBBS seats.
Yes.
That was the clarification given, banking on this notification of 12 August 2024. That is a very, very important point to be decided. So a presumption is being drawn, an inference has been drawn on the basis of this paragraph 1.5, which says about the adoption of reservation policy. Lordship may kindly appreciate here one thing. This reservation doesn't mean 100% reservation. They have adopted the reservation in the imperial order, 3 categories, 142, page number 142 of the writ petition. Because we have to be very clear so as to not commit any mistake, to avoid any mistakes. Reservation is shown in paragraph 2 of the notification of 9/9/2021 issued by the Government of Nagaland, Lordship. Here, Lordship will find as many as 5 categories, but we are concerned with paragraph 2, clause A, B, and C. Lordship may kindly see backward tribes reservation, 15%. We are not questioning this, and this is the normal practice adopted by the state, not only in this, because as I was mentioning the other day also, this is a general notification, not only pertaining to MBBS, but pertaining to engineering courses and allied services and agri and allied. It is a general notification of the state government, including the MBBS, medical and allied. It is not only for medical, it is for allotment of undergoing undergraduate courses in engineering and allied, medical and allied, and agri and allied. 3 categories. Under 3 categories, many things will come in, but we are concerned with medical and allied, where a specific notification has been issued by the Government of India. How to follow it? Now, by bringing a notification of 12 August 2024, my learned friend was trying to show, basing on a letter written by the director of the department, saying that, look, even if the concurrence of the central government is required, look, the notification of 12 August 2024 also shows in paragraph 1.1
1.5.
that, no, 1.5.
Yes. 1.5.
Reservation.
Regarding the reservation.
Yes. The reservation policy being followed by concerned beneficiary state will apply on central pool MBBS. I believe it is very clear.
Yes.
It doesn't mean that 10% reservation will apply, but it means about reservation by the state, 15% we are not questioning also, 5% also PWDs we are not questioning, 20%, and remaining seats, all remaining seats will be for indigenous inhabitants. Does it mean 100% reservation? Number one. That may be noted very clearly, Lordship. If so, again I'll come. Is it meant 100% reservation? One. Let us be very clear on that. If so, yes, it is 100%. Then, can we come to the notification of 12 August 2024? What does it mean? 1.2. This is beneficiary states, few states are only given, eligibility conditions. And 1.2, paragraph 5, Lordship. Has Lordship got it?
The children of central state, this one.
Yes. These should be treated at par with the local residents. What does it mean? This is the direction issued by the Government of India. If it is not going to be implemented, then what is the point of inserting this clause when 100% are reserved for the state? That means there has to be some selection from the central, from this category. But when you reserve 100% seats, how will it be possible? That means even if I made eligible, even if I qualified in the need by securing number one, I will not be selected. Why? 100% reservation has been made. Therefore, what I am trying to submit is, Lordship, the reservation policy adopted by the state means the existing policy of the state government, where they have adopted the policy of 15% reservation for backward tribes, 5% reservation for PWDs. But not remaining 80% can also be reserved for the state. If so, what is the point of inserting this clause in paragraph 1.2, paragraph 5? No meaning. Even if I'm eligible also, I will not be selected. Can there be a direction like that? Therefore, I have challenged 9/9/2021 on the ground that this is just in order to eliminate others, nothing else. Therefore, it is hit by Article 14 of the Constitution of India, and the central government guideline is very, very clear. It has not deleted till date that the children of the central government employees shall be treated at par with the local residents of the state, And the selection criteria will be on the basis of the marks secured in the NEET examination. If that is waived, then I'm not eligible and qualified. But that has not been waived. But on the basis of a vague statement, the state is trying to create confusion. Therefore, Lordship, even if confusion has been created, there has to be a solution. Now that my submission is, this is my understanding of the submission. 12/8/2014's letter, where inference has been drawn by the state that, look, reservation criteria has been adopted, so whatever notification has been issued on 9/9/2021 has been adopted by the state. That means entire 100% reservation has been taken by the state. To clarify this, there is a way out. The letter of 12 August 2024 is written by the Government of India, Ministry of Health and Family Welfare. And now that state is creating confusion, we are challenging before this honorable court that this is not the way and this is not correct interpretation. Let the Government of India, who has issued the order, clarify on this point so that all confusion will be cleared. Let them clarify whether it means 100% or reservation means the existing reservation of 15% backward tribes and 5% PWDs. It is only confined to that, or it means 100% reservation. I believe.
Understood motion, and I have a copy, and the two other revisions that has been filed, what has specifically directed extra copy be furnished to me, which is not furnished to me, and
I have also received only just.
I have not taken any steps.
See, Mr. Moa, ultimately, the court has to decide on what this reservation 1.5 means. Because the central government's direction is reservation policy being followed by concerned beneficiary state will apply on central pool. So you are saying that this reservation has been also upheld by the central government. That's what you're saying, isn't it? This para 2.
On the basis of that, Lordship, my friend, due respect to my learned senior friend, Lordship, other day I was speaking about the competency of this state government to formulate notification.
Yes, yes.
That was under Article 247, and the concurrent list. Concurrent list, it is given that the state government is competent to formulate any policy.
So
the policy of the state, Your Lordship, because main challenge is, my learned senior friend is talking about other things. I'm coming to the main challenge.
9 September.
9 September
2021.
challenge. Yes. Now, leadership, please find out.
See,
an
that
authority.
Indra Soni's case, where it is said even
It cannot
80%,
exceed 50%.
even 80% is not possible.
Yes.
But some differentiation has been made by the Supreme Court in another case. I don't remember it, but regarding job reservation.
Yes.
But regarding this MBBS reservation, Supreme Court in one case, I think Pradeep something, you just find out, okay, it says that domicile on the basis, reservation on the basis of domicile, other kind of reservation is possible where MBBS seats are concerned, because it differentiates between job reservation and MBBS seat
seats,
reservation.
yes. And even among the MBBS,
Yes.
undergraduate UG and
PG is
PG
different.
has
Yeah,
been
that is also
distinguished.
different.
The
Yes.
same principle cannot be applied in respect of
Yes.
PG.
PG is
Yes.
again different.
Your Ladyship, I'll come to this point.
Yes. So
The competency of the state to frame a policy. This is because 9/9/2021 is the policy of the state.
That is
Policy of the state. And
see,
when to interfere, when not to
if
interfere.
we modify the interim order, the entire petition will become infructuous.
Correct.
Because ultimately, how will the state get the seat from somewhere? You'll never be able to get another seat.
Never.
If
Impossible.
the petitioner succeeds, you'll never be able to get another seat.
Yes.
Then that's why it's better to dispose of this petition. Can we list it for hearing tomorrow? Treat this as your affidavit in opposition.
If
Tomorrow,
that is
day
your
after.
opinion
Yes,
of the
Lordship, yes.
Because
Can be listed for hearing.
regarding the-
If you have something more to add to this, you can always file. Otherwise, we can take this as your affidavit in opposition, this your IA.
Besides this, there will be no other points, I believe.
If you have some other points,
Even if, I'm not questioning their competency, they have the power to frame law, but it has to be in consonance with Article 14. That is what I have questioned and challenged.
I'd like to read one authority, Your Lordship. Please find.
And
Please
Lordship
find
is well aware about the Article 254. It is a direction by the Government of India.
Only one authority, Your Ladyship.
yes.
This 2015 2 SSC, page 796, para 3032. This is a three-page judgment including this, the 10 CGI. Lordship, I'd like to take you to para 30, 31, and 32. Page 808.
Page
808, para 30. While dealing with the, may I read, Your Ladyship? While dealing with the power of the courts and interfering the policy decision, the court ruled that 54, it is not in the domain of the court to embark upon an uncharted ocean of public policy and exercise to consider as to whether a particular public policy is wise or a better public policy could be evolved. Such exercise must be left to the discretion of the executive and legislative authorities, as the case may be. The court is called upon to consider the validity of a public policy only when the challenge is met that such policy decision infringes fundamental rights granted by the Constitution of India or any other statutory right. Procedural 31. The executive authority of the state must be held to be within its competence to frame a policy for the administration of the state, unless the policy frame is absolutely capricious and not being informed by any reason whatsoever, can be clearly held to be arbitrary and founded on mere expediency of the legislative functionaries, thereby offending Article 14 of the Constitution, or such policy offends other constitutional provisions or come into conflict with any other statutory provision. The court cannot and should not outstep its limit and tinker with the policy decision of the executive functionary of the state. Your Lordship, 32. The court cannot strike down a policy decision taken by the government merely because it feels that another decision would happen fairer or more scientific or more logical or wiser. The wisdom and advisability of the policies are ordinarily not amenable to judicial review. Unless the policies are contrary to statutory or constitutional provisions or arbitrary or irrational or an abuse of power. So, Lordship, how can notification dated 9/9/2021, which was been followed for the last 4 years, my learned petitioner has come and said that this is bad. We have followed since 2021 consistently without any interference. We are following that, religiously following the notification. And notification wasn't framed with the competence of the state. Because congruent list is very clear. Schedule entry 25 in the congruent list is very clear. And the strength derived from the Constitution of India will frame the policy. And it is continuing. Only today it is disturbing in 2026.
Policy should be in consonance with law. And the citation which my learned friend has referred to.
What if it is in conflict with this 12 August 2024 OM of the central government? Then, which will prevail?
This is an apex court
just a
judgment.
question.
This is an apex court judgment.
No, no.
No, it supports my case,
That is
Lordship.
different. That is different. I'm talking about your notification of 9 September 21 and the central government OM of 12 August 24.
And
If it
13 is
in
also there.
Your Ladyship.
If it is in conflict,
No,
then
no. This is a circular made by a Ministry of Health, Health, Government of India only. A circular.
it is an office memorandum. Office memorandum.
Yes.
Office memorandum of 12th August 2024. And state government is a notification.
And so far as Nagaland State has been concerned, Nagaland State is competent enough to frame any policy. You see, we have a different state. Our state is a different for the different state.
But this para, I admit that this para 1.5 needs to be interpreted. The reservation being followed by concerned beneficiary state will apply on central pool. So this means this reservation at para 2.
Lordship,
In this OM of 12 August 24, in para 1.5, it says that the reservation policy being followed by the concerned state will apply on central pool MBBS seats. So you are relying on this, isn't it?
Yes.
Lordship, I would like to clarify this OM because
See,
this
Mr.
was from your Ladyship. This wasn't brought in by my learned friend. Lordship, your Ladyship, can you see this?
Other day, my learned friend has referred a letter written by the director, which has referred
The
to this
director
letter.
has referred to
Basing
this.
on this letter, Lordship has passed an interim order. Otherwise, Lordship was inclined to issue a direction to the state to comply with the directives of the central government. But in view of the confusion created by the letter issued by the director,
your Ladyship,
basing on this
please
notification,
to-
but
please
see
this is
whether it is in
memorandum
consonance with law or not.
dated 28 July 2025.
Same, here also same thing, para 1.5.
The reservation policy being followed by the
Same
concerned
thing, yes.
beneficiary state
Same thing.
will apply under central poll in the base
That's
PDC.
why I'm saying, yes. So, you're saying that this reservation policy followed by the state is also adopted by the central government. Central government has also allowed the state to follow this reservation policy. That's what you're trying to say.
Yes.
And now the petitioner is challenging this reservation policy.
On the ground that it is not in
the
terms
ground
of the
that- yes.
Government of India notification.
But your Ladyship,
Yes.
without staying this policy, 9/9/2025, order has been passed on 28/7/2025 and more particularly on
That is a
31/7/2025.
Yes. This 9.
Please appreciate the grievance of the state also.
You have not pressed for stay also. This 9/9/21 has not been stayed.
It has not been stayed. That's not been stayed.
It has not been stayed. So if it's not stayed, then you don't fulfill the criteria.
Which criteria? It is under challenge.
No, but there's no stay.
That is the reason why the other day I have been trying to draw your Lordship's attention to this paragraph 2 again and again, because we should not commit any mistake. Ultimately, the law has to prevail. If I say anything, if my learned friend says anything, if it is not in accordance with law, this honorable court has to interfere. And we have challenged this 9/9/2021.
That has been challenged. But the whole thing is, if it's modified, the writ petition will become infructuous. That's the whole
Yes.
thing.
Lordship, we hear it.
So
Because
I would
your
like to
Lordship,
draw your
see,
Lordship's
if we
attention.
follow the 31/7/2024 order, if we follow,
So
then
it's up
it
to
is
you.
it is as good as
The court is ready to hear anytime.
Lordship, can we come to page 58 of the writ petition? 58. Page 58.
Writ petition.
Yes. Annexure F. This is the similar notification with that up to 12 August 2024.
58.
And here, 12 August 2024 letter is referred in clause 5. So, Lordship has correctly expressed that.
Just come back in 5 minutes. Sorry.
Lordship. Understanding varies from person to person. And I think from my personal perspective, you think from your personal perspective. So let the vote is on. The best person to give a clear explanation on this. What does it mean? Because everything is arisen out of your letters. And the state is trying to interpret that from their perspective. They are also trying to interpret from their own perspective. Lordships, I was trying to draw your Lordship's attention to page 58 of the writ petition. And I was referring to paragraph 2, Roman 5, towards the bottom of the page. The selection of eligible candidates will be made as per the guidelines issued by this ministry of 12 August 2024. The copy of the merit list together with the copies of allotment letters may be sent to this ministry. A new guideline has been issued this year, and that is before Lordship. And just one paragraph below that, let me finish this.
Yes.
Roman 6. Any complaints, grievance with regard to the selection of candidates may be redressed in a time-bound manner. This is the urgency of deciding the matter, Lordship. Whether it is in the common level or before the Honorable Court
That's
also,
right.
it has to be in a time-bound manner.
It has to be
And
redressed urgently.
what Lordship has expressed is your concern for expeditious disposal. I'm agreeable to that, and it can be disposed of tomorrow, and this can be treated as an affidavit.
Mwah, can that be done? Because we understand that there is urgency because seats are allocated, then after that admission process, and if this petition holds up the entire selection process, then it will be not in
Difficult.
the interest of anybody. tomorrow?
No problem. If
So
your lordship insists, then no problem.
Yes, yes.
If necessary, I can file a short reply tomorrow itself. It will be a short, if necessary.
And will you be filing anything else besides this IA? Any addition to this?
If advised by the government.
What do we have to go ahead? Because
On the basis of the
urgency is-
materials available on
on the
record,
basis of
lordship can
materials
decide.
is, this is an application under section 151 of the CPC, praying for clarification / modification / alteration of the order dated 31/7/2025, passed in WPC 138 of 2025. Stop. Head Learned Counsel for the state respondents, Senior Government Advocate Mr. Moa Yingchen, and also Mr. Siti Jamir for the petitioners / opposite parties, and also Mr. Yangarwati, CGC, for the opposite party number 2. That City will be for 1, opposite party 1, and Mr. Yangarwati for opposite party number 2. After hearing the parties, this court is of the view that this petition needs expeditious disposal, and accordingly the matter may be listed for admission hearing. It's possible
Tomorrow.
tomorrow,
As a first matter.
i.e. is
Lordship,
First matter.
i.e. 5th August as item 1 in the admission. The IA number is IA 144 of 2025, filed by the state respondents, shall be treated as the affidavit in opposition by the state respondents. The state respondents are also permitted to file any additional affidavit if so advised.
The petitioner may be allowed to file reply,
May be also to
if so
is
advised.
also allowed to file reply if so advised.
And the other WPC 134 of 2025 may also be taken together along with this.
Oh, yes, yes. WPC
134
this matter
of
along
2025.
With WPC 134.
Yes.
134 of 2025.
134, 2025 and 138, 2025.
Yes.
No, that is the
Together,
present one.
Together, yes, together, as directed.
For hearing, item number 15.
May it please your lordship.
Yes.
Your lordship, my apprehension was unfounded because I did some research, but I don't want to give any comments. If I give comment, it may have an adverse effect on the other proceeding, and that may be taken on record. So as far as the voluntary service is concerned, in the Home Guards case, the Honorable Supreme Court has already decided. So though they are members of the same organization, voluntary and already in the regular service, no comparison can be made. So,
Oh, what are you on now?
now on the L zone,
Okay,
the village guards.
That case.
Yes, Your Lordship. So the only question is whether in the interpretation of the state respondents of the ROP rules of 1993, that Nagaland police and home guards are of the corresponding service. Now, the only question is whether the interpretation of the state respondents that the Jamadar, which is actually in the rank of assistant sub-inspector, should be equated with a constable, whether that is fair or not. Whether the subidar that is in the rank of sub-inspector, whether equating that same with the two stripes, that is Nike, whether that is fair or not. And whether the subidar major that is in the rank of inspector equated with the sub-inspector, whether that is fair or not, because the next promotion is in the same rank, same pay scale, that is Assistant Commandant DYSP and SDPO.
On the last date, you said that you wanted to clarify whether that WP 110 of 25
Yes,
may
which
have a
is
bearing
filed
on
before
this
the,
case.
yes.
So you're saying that it is different?
I thought it may have some adverse effect on the findings of this Honorable Court, but there is no relation whatsoever. Because the Honorable Supreme Court, as far as the voluntary service is concerned, they have defined in the Home Guards voluntary services cases. And I did not.
Otherwise, I think the court had heard you.
Yes, Your Lordship, it's already fully heard. So,
But I've forgotten the facts.
oh, Your Lordship. So here, what happens is, if we have to take the interpretation of the state respondents, the promotion from, since the Jamadar, which is in the rank of Assistant Sub-Inspector, is equated to Constable. I believe my Lord had made some notings also.
Yes. Now I'm seeing the notice.
Yes.
Because I've not read
So,
the records.
litigation, since it has gone on for the last 6 years.
This is regarding some ROP.
Yes, Your Lordship.
Yes.
So, my Lord, here, if we have to take the interpretation of the state respondents that Jamadar in the rank of Assistant Sub-Inspector is equivalent to Constable, if we have to accept that, Subedar in the rank of Sub-Inspector is equivalent to Naik, and the Subedar Major in the rank of the Inspector, which is the rank below the DYSP and Assistant Commandant, Your Lordship. If that interpretation is to be accepted, assuming that that interpretation is correct, then we are also to see whether, under the doctrine of reasonability, whether it is reasonable to accept the argument that from constable in the police, a corresponding service, whether in the police department a constable is directly promoted to Naik, that is 2 stripes, and 2 stripes, that is below the rank of Sergeant Havildar, 3 stripes, whether that can be, whether a promotion from Naik can be directly promoted to sub-inspector level 2 stars, from 2 stripes to 2 stars. So, my Lord, the second part of the reasoning that can be not admitting, but if it is to be accepted, for instance, because the qualification entry level and all, it is different, which is an accepted fact. So, my Lord, assuming that the first part of the argument is correct, then again we take the second part of the argument, Your Lordship, on reasoning. If the Subedar Major in the rank of Inspector is given the rank of Sub-Inspector, that is 1 rank down, if that is to be accepted as reasonable, then what about the other ranks? For instance, if that is to be accepted, Subedar Major in the rank of accepted as a Sub-Inspector level, then Subedar in the rank of Sub-Inspector should be accepted in the rank of Assistant Sub-Inspector, and Jamadar in the rank of Assistant Sub-Inspector at the least should be accepted at the level of the Havildar, that is 3 stripes, Your Lordship. If not, if that interpretation of the state is to be accepted, saying that since their entry level, number 1, the village guards have no service rules. Number 2, their entry level qualification is low, so they cannot be given 100% equality. If that is to be accepted, still, at least in the rank of Subedar Major, which is equivalent to Inspector, if that is given the pay scale of the Sub-Inspector, which is 1 rank down, then the same uniformity also should be applied in the other 2 lower categories also, Your Lordship. If not, from Constable to Naik, 2 stripes, and from Naik 2 stripes to again directly 2 stars. That interpretation, Your Lordship, it's highly unreasonable and unfair, and it erases the entire meritorious service that the Village Guards organization has rendered over the years, getting multiple Ashok Chokras and other gallantry awards in the history of their services.
Now I remember now.
Yes, Your Lordship.
There was one anomalies committee report also.
Yes, Your Lordship. But that anomaly report, it came to this court after 5 years of filing the writ petition, Your Lordship.
Your Lordship, that report is my affidavit dated 3rd September 2024, Annexure 3,
Yes, page 32.
page 32.
Corresponding pen and you have challenged this also?
No, Your Lordship, it is after 5 years.
After filing?
Yes, after filing, after 5 years after filing this writ petition, this record was brought, which means, with all due respect to my learned senior colleague, there has been no sincerity whatsoever on the part of the state respondents. And this proceeding before this Honorable Court has not been taken seriously all these years. And now at this stage, we cannot go back to square one. That is why, Your Lordship, I have used some authorities which says that when the fault is not attributable to the candidate, then exceptional relief has to be woven by the Honorable Court in favor of the petitioners.
And then the ground taken by state respondent was?
That, number one, our qualification, our entry-level qualification is not, equivalent. So that is an accepted fact, Your Lordship. Number two, we have no service rule to regulate. But the interpretation given by them, whether it is fair or not, because the 1993 ROP rules clearly stated that Nagaland Police is a corresponding service of the Village Guards organization. And still in some areas, Your Lordship, the police stations are being managed by the Village Guards. As on today, as I stand before this Honorable Court, I do not know, but over the years, and then we have filed affidavit also to show that some areas where there are no police stations and then village guards also functioning as the police station.
But when entry into service is different mode of recruitment, different
Yes.
No, that is why, Your Lordship.
Duty and responsibility also quite different.
Different department.
Oh, no, duty is similar, Your Lordship,
And
but
duty and functions different, they're saying is different.
no, even otherwise,
Can
Your
the
Lordship.
court examine?
No, that is why, Your Lordship.
Whether duties and functions are same or not?
Now, on the reasonability of whether the interpretation is correct or not, if we have to accept their interpretation, a constable is directly getting promotion to 2 stripes Nike. From 2 stripes, the next promotion is sub-inspector. It comes that way. So it is totally erroneous, and it is, without application of mine at all, Your Lordship. Because assuming that we are to accept
there are certain things where this court in its jurisdiction cannot enter into.
Yes.
And all this, the court is not aware whether these duties and functions are the same or not.
No, we have filed our affidavit.
No, that is there, but they're
Yes, Your
denying.
Lordship. No, they have to deny by way of affidavit. They have not denied by way of affidavit. The additional affidavit that was filed on 17th of April 2022, filing of additional documents.
No.
Additional affidavit.
I filed 3rd September 2024 regarding the report of the Committee on Anomalies.
So, Your Lordship, as far as this affidavit is concerned, may I take Your Lordship to the affidavit, that is 17/4/2022. The filing of additional documents in additional affidavit.
Their first affidavit is 9/2/21 and additional affidavit is 3rd September 2024.
Yes, and as far as that is only to produce the pay anomaly committee report. But where we have claimed that we are also performing the same duty, this affidavit has not been contested, Your Lordship.
Lordship, our affidavit, we have already clearly stated that two petitioners are not equipped with the general police.
I'm talking about that we are functioning as police station, that they have not disputed, because it is an admitted fact, Your Lordship.
Just functioning doesn't qualify. The responsibility, its value, everything has to be taken into consideration, and for which the reasonableness, we base on the reasonableness.
Your Lordship, submission can only be on the question of law.
Did you have the
not on the facts. Facts have to be disputed by way of affidavit, Your Lordship. Law is a different issue, but duties that are being performed, which are similar, supported by factual documents, Your Lordship, that cannot be disputed by way of argument, my lord.
Now, affidavit, whatever affidavit we file is, it has become part and parcel of the record. Everything is there.
Your lordship, may I take, is my lord on the affidavit filed on 17/4/2022 by the petitioners?
Additional documents.
Yes, your lordship. And that is additional documents in additional affidavit for and on behalf of the petitioners.
Yes, yes.
To substantiate a writ petition to show that the JCOs of the village guards performs corresponding duties of their counterpart in Nagaland police.
Yes.
So, your lordship, if I may take your lordship to page 3, starting from para 2. White order number so and so dated Mon the 7th December 2015, the village guards were directed to perform guard of honor to the Honorable Governor of Nagaland and Assam in Mon HQ. Then next, your lordship, these are all supported by documents. White order number so and so dated Pungro the 10th November 2016, passed by the Additional Deputy Commissioner Pungro Nagaland. The common security detailment order was issued for security arrangement for law and order duty in view of the visit of Joint Secretary, Ministry of Home Affairs, Government of India to Pungro town. The 2 section of 4th NAPIR at serial number 1 to be stationed at helipad ground Pungro town for anti-sabotage check and sanitization of helipad. And at serial number 4, the village guard post Pungro town Commander Pungro town was directed to initiate a patrol of the outring road of Pungro town to thwart any possible threat. Then, your lordship, the next is Noglak, 22nd March 2017, by the Additional Deputy Commissioner Noglak, directed the OC Police Station
Have you
Noglak.
filed any rejoinder to this?
No.
Additional documents?
Well, your lordship, the thing is, whatever duty they have rendered, we have shared, but it's a particular portion of the state. You see, the general police, they have participated.
And they are not in, they are not,
You are not peacekeeping force in other countries.
They are not in all parts of the state, your lordship.
Yeah, there's a difference. Is there any village guard rendered duty in the Kohima and Dimapur and Moksop? They have considered confined only a particular district. So that's a difference. That's a difference. Responsibility, the value, and the duties. That's a difference. And we are guided, general police are guided by the law. And you are appointed by the village authority. So there's a big difference. Of course, a petitioner has a right to submit. But the thing is, there is a big difference. You see the police, general police, Nagaland police, they have participated even in the UN peacekeeping force in other countries also. So we are guided by the law. So that's the difference. That is my submission.
Your lordship.
This is confining only a particular area of the state, village guard. Whatever duty they have rendered, we have received, and this is for the state. We have received, but their duty, responsibility, their jurisdiction is confining only to a particular area of the state. So they
That
cannot
is in
be
international
applied with the
border
general
areas, your
police.
lordship.
Yeah.
International border areas.
Village guards are there in Tuinsang and Mon.
Kifri also, your lordship.
Kifri, Tuinsang,
Yes,
Mon,
that side
Kifri.
only.
Noglak.
That side only. Other side of the state. Simultaneously, Nagaland police are there, men there.
That is part of Nagaland. You can't say other part of the state.
Okay, and then your
All the
list of
authorities have
authorities
also, yes,
is here.
it's placed before
State
your lordship.
respondents is also here. Acha, Koza. This one, state respondent, this compilation is there, okay? Then this is the petitioner's list. I don't know whether petitioner's judgments have been satisfied or not. No, the relevant harassment they have stated. You can take this, it's okay. No. So, the You are referring to this, na? This is your
Yes, Your
list
Lordship.
of authorities.
Yes, Your Lordship.
In all the authorities, he has given the background. So, I need only the particular background, not the whole judgment. No? Just tell them to give it. Okay.
My Lord.
Yes, third counsel for the petitioner, Mr. Joshua Shetty, also like Mr. M. Thompson for the additional AG for the state respondents. Judgment is reserved.
Obliged, Your Lordship. Your Lordship, after 6 years, finally this hearing is concluded.
Oh, really?
Yes.
Why was it kept like that, pending?
My Lord, one factor after the other has kept this matter pending for too long. Obliged, Your Lordship.
For hearing, item number 23. Please, Your Lordship, my senior is on left. He might be arriving shortly.
Who's for the state?
I'm sorry.
The other side is not there.
Coming.
Oh.
We were together. By an order of the court, taking steps has been already deleted, Lordship.
Service.
There is a checkered history of litigation in this particular case, but the issue involved is very, very simple. Because we are challenging 3 orders of the Deputy Commissioner of Kohima, who has passed the order in connection with the land dispute arising in Viswima village.
This respondent 4, 5, and 6 notice deemed served.
4, yes.
Which order? Oh, Ashipri is there.
1, 2,
You are for?
and 3.
As per the amended memo, I'll be for 2.
1, 2, and 3 has been deleted, and 4, 5, and 6 have turned to 1, 2, and 3. Lordship, again, you see order dated 3/12/2024. 3/12/2024.
Okay, so respondent 4, 5, and 6 are renumbered as 1, 2, and 3.
Yes.
So now Commissioner Nagaland, Deputy Commissioner, they are no longer there.
Yes.
Yes, 1, 2, and 3 are
Since
no longer there. And Chairman Visima Village is 1. Chairman Zeri Khel is 2.
Yes.
And Tenuswili Clan is 3.
Yes.
Okay. It's okay. Supervision, 12. Okay. Yes, arising out of a land dispute.
Yes.
Yes.
I would like to summarize the case in a nutshell. Otherwise, there is a checkered history of litigation from village council, from KEL to village council to STO Chakama, STO Chakama to DC Kohima, DC Kohima to again village council to again the DC, and then came back to village council and then to DC. So in short, I would like to summarize in a nutshell before I refer to the documents, and I feel that it is not necessary to go into all these details because this Honorable Court will not be the appropriate forum to declare right or wrong. Where the court has gone wrong, this is to be examined by this Honorable Court. So I will confine my submission only on that. But before that, how the dispute arose in a nutshell, Lordship. I will not refer to the document at this stage. This is a land dispute, the forest land, on the way to Tsiko Valley, within the jurisdiction of Pesima village. So there was a dispute between two clans. In Pesima village, there are 4 kills. Out of the 4 kills, we belong to Ziri Kill. And we belong to, the present petitioner belong to Tsikro clan of Pesima village. So, there was a dispute between Tsikro clan and Kinau clan, land dispute, because Kinau clan wants to encroach our Tsikro clan's land. Therefore, since the issue is conversant by the village council, and normally, as Lordship is well aware, in the village when there is some dispute, first, in Angami, I do not know in detail, but then it was brought to the knowledge of the KEL. So it was brought to the knowledge of the Ziri KEL. The dispute was between Tsikro clan and Kinau clan. And that dispute was brought to the Ziri KEL. How Ziri KEL has decided?
Why it has decided?
Very interestingly,
2 other kills.
Neither of you are the owner, I am the owner. So the judge has taken the land. The Ziri KEL has taken the land. He took the entire land. Initially, the dispute between the 2 clans was, no, this is the boundary, and one is saying, no, this is the boundary. But ignoring about this boundary, this here and here, entire chunk of land is mine. Neither of you are the owners of the land. That was the decision taken by Ziri KEL. So, since the decision of the KEL was not proper, the matter was taken to village council. KEL is also under village council. So it was reported to the village council, Pesima. So we were waiting, but no decision was taken. Rather, in the meantime, you don't file this case, why you have filed, all these things are there, but I'm not going to that. So since there was inordinate delay by the village council, Tsikro clan, who has taken the matter to village council, they approach STO Civil Chakama. That look, this matter has been given to the village council, but they are not deciding the case. Instead, we are subjected to so many undesirable situations. So please examine this. So it was given to STO Civil Chakama. Summons were issued on the basis of the complaint and then application. But then Ziri KEL did not participate, did not come for the proceedings of the case, for hearing the case. So admittedly, the case was decided ex parte by STO Civil Chakama in favor of the Tsikro clan. Now, Ziri KEL, Ziri clan, has approached Deputy Commissioner Kohima under Rule 29 of the Rules for Administration of Justice and Police in Nagaland. Lordship is well aware. With a plea that, look, we were not hurt by the STO civil Jakama. So please examine this. So what happened? In other words, to put it in a legal term, the order passed by the STO Jakama is an ex parte order. So please examine. That was the complaint taken by Ziri clan to Deputy Commissioner. Deputy Commissioner, by another ex parte order, without inviting us, passed an order directing the village council of Visima village to decide the case.
The case which was pending before them.
Yes, yes. It was sent back to, order of the STO civil Jakama was quashed by the DC. Thereafter, he has sent it to village council Visima. So, an endorsement by the DC, the village council has decided in favor of the Sirikel. There are so many reasons cited, but then I am not going to that now. So against that judgment and decision of the village council, the present petitioner, the Chikru clan, submitted representation to the Deputy Commissioner Kohima to examine and hear them on this case. What happened? Entire proceeding was conducted by STO Civil Jakama. A spot verification was also conducted during that time without inviting the petitioners during the spot verification. STO Civil Administration and Village Council has inspected and maybe apparently they have submitted the report also. But the petitioners were not invited for that verification, which is reflected in the Deputy Commissioner's order also. And then during the hearing, all evidence, everything was placed before STO Civil. After that, Deputy Commissioner has also summoned us one day. But that was invited separately again, on the same day, no doubt, but not heard in the open court in presence of both the parties. DC has called our clan, and the other clan was called after us. That means separately it was called in his office chamber. And the order was passed. Basing on the order which was passed by the village council, which order was based on a direction issued by the Deputy Commissioner Kohima, which was an ex parte order. Therefore, the very exercise of jurisdiction by the village council has been done basing on an ex parte order, and basing on the village council's decision, the Deputy Commissioner Kohima has passed the present imbued order. I will cite one example. In short, during the hearing, there was a record of a hearing of this particular case, Forest Land Case 1 of 1978. A record was shown. We insisted that we have record of this proceeding. Please see. Tenosele and the Chikru's clan dispute case has been heard in 78. Please see the video. We have the record. DC said, no, we are not going to see the record. But we have filed and placed before the DC. After some time, we were informed that, no, the video which you have furnished is damaged. It is not visible. So it is damaged. But DC has relied on a judgment given by the village council, who has relied their judgment basing on a 1925 order purportedly and allegedly passed by GP Mills, DC GP Mills. Now, to my knowledge, G.B. Mills has written so many books and hours like that. But Angami area, it is Houghton, who was the STO civil, STO in DC. Be that as it may. The Deputy Commissioner, he relied on a judgment of 1925 allegedly passed by Chief Mills. We insisted that before the village council as well as the Deputy Commissioner, if at all there is any order, such order deciding about this case, please show the order and examine the order and arrive to a conclusion, just decision. That was our plea before the village council as well as the Deputy Commissioner. But that was not taken into consideration. So two aspects here, two important aspects. Of course, I will refer to the document. First one, 1978 decision in Forest Case 1 of 78, where there was records. The court declined to examine that. That is one. And relied on an order, allegedly an order issued by, passed by G.P. Mills in 1925. No record was shown, no order was placed, but during the hearing, somebody may have prompted that, and basing on that, order was passed. Now,
that order was not on record.
Not on record. So, evidence on record was ignored, and a thing which is not on the record, there is no evidence, finding was based on that. But most important thing for approaching this honorable court is the matter was heard by STO Civil. Entire evidence, everything was placed before STO Civil Jakama. And only one day, as a showbiz, Deputy Commissioner Kohima has called us and heard one day in the sense we were invited, we were asked to narrate our story, and after we left, they were allowed to narrate their story, and he has passed the judgment. So my question is, by approaching this honorable court is, when the STO Civil has heard the matter, he ought to have passed the order, and if Deputy Commissioner, who has heard one day at the end, if he is to hear the matter, he should have heard from the beginning and pronounced the judgment, basing on the evidence and the statements made by respective parties. That was not done. So, on the basis of an ex parte order, where we were not given opportunity of being heard, basing on that judgment, the village council has exercised their jurisdiction and passed the order, and basing on the village council's jurisdiction, the Deputy Commissioner has passed the impugned order. So, I'm challenging three orders of the Deputy Commissioner. The first one being 27/4/2022, Lordship will find at page 120. During this proceeding, we were not heard, and so many dislocations have been made. And by this order, the substance of this order is the Deputy Commissioner has remanded the matter to the Village Council, Kohima.
Annexure 21.
Yes, page 120, Annexure 21. And against this order, this is order passed on 27 April 2022. Yes, and against this order, Ziri Kel has filed a review. Which Lordship will find at page 122. In what manner it was passed, in what manner it was filed, by reading the order, Lordship will know.
Who filed this? Ziri clan?
Yes. They file a review against this order of 27 April 22. And then page 122 is the order of the DC, where the petitioners were not heard. This is an ex parte order. Just one page order, Lordship. May
This is
just
ex
have a
parte
look on
order,
this.
and that other one, 27 April, also ex parte. 27th April 22, DC's order, page 120.
Yes.
This is also ex parte order.
This is also an ex parte order.
This was filed by the Zeri clan.
Yes.
Then 1st July 22 also ex parte.
Yes. And then by this order, it was remanded to the Village Council, Wesima, as Lordship has seen in page 122. And the Village Council's order, Lordship will find at page 182, starting from 183.
182.
Yes. This is the forwarding letter, page 182.
Judgment is 183.
And the judgment is at 183. During the hearing before the village council,
27, 422, 173.
we have categorically pointed out to the village council that 14/3/1925 Chief Mills order is not on record. So that was our categorical stand and submission. But they have not denied that, totally silent. And if we look at 197, page 197 also, they have referred in the DC's order about the JP Mills case, but it starts from village council. Our contention was totally ignored by the village council. Therefore, after deciding the case by the village council on 15/9/2022, the petitioners...
You are challenging this village council judgment also?
No. Because DC has remanded the village council and DC has relied on this judgment.
DC has relied on this 15/9/22 judgment.
Yes, and we have submitted the representation. Kindly see our representation also. It is only 2-page judgment, so I may be allowed to read.
What did the village council say?
Village council, kindly see the decision at page 185. The village council, after examining the statement and hearing the parties, decided as follows. 1. A copy of the judgment of forest case number 1 passed by Seasonal Chairman and Seasonal Secretary on 17/4/1978 is not valid as per submission at para 4(1), 2, 3 of the observation. They have made the observation in the page 184. And 2. The dispute area ought to belong to Zirik Hill, in which Secret clan has also a share in it among the 9 clans of the Hill. Henceforth, no road works, so and so, some direction has been made. Against this order, the petitioners submitted a representation to the Deputy Commissioner. And kindly see the
Page 188.
188. I may be allowed to read this representation, Lordship. Do the Deputy Commissioner, subject dispute over a forest land between Tenoseli clan, Chakru clan, and Zetkel Cape beneficiary of Visima village. Appeal against the verdict given by Visima Village Council, White dated 15/9/2022. Sir, with reference to your order number so-and-so, 1st July 2022 and number 38/2022 on the subject cited above, in which Visima Village Council was directed to take up case within the time frame contained in these orders, we would like to bring to your notice our grievances consequent upon the verdict issued by the Visima Village Council, White order dated 15/9/2022. That, sir, upon receipt of your copy of the same, it must have been apparently become clear that the verdict was lopsided and without watertight proof due to several reasons as may be stated under. 1. Vesima village comprises 4 khels, namely K khel, P khel, R khel, and Z khel. The land dispute involves Tenoseli clan from R khel, Chakra clan, from Z khel and Z khel, who are beneficiary of a gift by Tenoseli clan. As such, members from 3 khels deliberated on the statements made by the parties, but predictably, signatories of the verdict belong to 1 khel only. This is also important, which goes to show that a consensus was not arrived at K khel and P khel refused to sign the document. 2. It can be surmised from the statement of the other parties that Z khel should not come into picture as a contender, since it is an admitted fact from themselves that it was a beneficiary to a gift deed. The land in question is contested by a primary owner only by Tenoseli and Chakra clans, for which reasons the nature of deliberations should change course. To let it or not to become a common property as contained in the verdict will become clear only once contention is settled. 3. Very conveniently, all the reasons presented to justify the verdict arrive to have ignored our side of the clans. This is important, which we supported with solid evidences. For example, names of some people who had sought permission from our elders to extract forest products from the area as recent as less than 10 years back, the same people blatantly denying their act because they are changing their stand and words also. 4. From the way proceedings took place in the hearing, it is very unfortunate that the present day generation is ready to alter even little history that was recorded in written, which was passed down to us by elders, fortunate to have had some writing knowledge, otherwise orally done those days. If required, original copy is still in custody, which may be put to test to prove its authenticity. Putting to doubt even such a rarely available record only casts serious doubts on the intentions and sets a bad precedent for posterity. Our claims have been thoroughly perused by STO Civil Jakama earlier too, when his office took up the matter and a judgment also issued, copy enclosed. But following your order that the village council should try the case afresh, we agreed to the request but hugely disappointed by its outcome. The verdict does not even make mention of any opportunity of an appeal if the same is not accepted. Our clan members have already been subjected to various forms of rejection owing to this case. So requested to examine the matter with the DC. After this, Lordship, what happened? Of course, these are not part of the dispute, but then the consequences up to the order. At one point of time, we were denied to issue scheduled tribe certificate, indigenous inhabitant certificate, and ration cards, everything. All this happened, stopped. And in the colony, the dustbin collection is also done. Our colony, our khel has not been given that right to even put in the colony vehicle also. To that extent. So subject to so many unnecessary, undesirable actions. But then the only option is to approach the court of law where it has to be decided in accordance with law. And Then the DC has passed the judgment. Lordship will find it page 192.
After you submitted the representation,
Yes.
DC took up the matter.
We went for an appeal. This is an appeal
don't you
to the
filed an
DC. And
Against the village council decision.
yes. And Lordship will find it page 192. And I think time is already run out for the first half.
Yes, we can continue it.
Start with the ambient order in the second half, Lordship. I will not take much time because it is with regard to the exercise of jurisdiction only, without going into the detailed merit facts of the case, Lordship, because it will not be necessary.
Yes. You were on judgment and order dated 3rd July.
Yes, page 192. In the first half, I was referring to the hearing before the Deputy Commissioner.
Yes.
All the statements, notice was issued by the STO Civil Jakama and all that, and we were called by the DC also. And so far as our party is concerned, the petitioner's party is concerned, the statements given before the Jakama STO Civil, is it correct? And the documents which you have furnished to him, is it okay? And we said yes, but kindly see the video recording which was done in 2021. Lordship may remember we were conducting a case of Dimapur in the land dispute case, Nija Angami. It was a long pending case, yes. Nija Angami's younger brother was the seasonal secretary in one by name Huiti Angami. It was in 1978, he was the seasonal secretary. Before his death, in 2021, what is the recording? 14 to 2021, he has given a statement about this proceeding in 1978. So we insisted Deputy Commissioner that, look, there is a video recording of the proceeding of that case of 1978. Can we have a look on this video? No, today it is not necessary. So he declined. Later on, we were informed that it is not visible and video is damaged. That was the information we got. I'm just trying to project the hearing, what type of a hearing, what kind of a hearing was done before Deputy Commissioner. We were invited, only that question was put, whether it is correct or not. Yes, we have given all the statements before the STO Sabal Jakama, but besides this, can you see this video? He declined. We have made categorical statement in our rating also. So that's how it's finished. And then other party, I would not know what type of questions were put to them, and then like that. And then judgment came. Now, I will not read the entire judgment because these are all, that question was for this and that, all that. But the first paragraph and thereafter I'll take to the relevant portion. I hope Lordship is at page 192.
192, yes.
Case number is Civil Appeal number 1 of 2022. The order date is 3rd July 2024. Appellant is Chakro clan. Respondent is Siri Kel and Thinoswili clan. 2 clans are the respondents. Both are present, Lordship, today. Judgment and order. The matter was taken up for appeal basing on the appeal petition submitted by Sakrul Chakra and Sevizo Chakra on behalf of the Chakra clan, appealing against the verdict passed by the Visima Village Council dated 15/9/2022, stating their disappointment on the outcome and that no opportunity for appeal was given. The appeal petition was taken up for examination under the provisions of Rule 31 of the Rules for the Rules for Administration of Justice and Police in Nagaland 1937 as amended. Thereafter, I would like to take your Lordship's attention to the relevant portion 196, the last 2 paragraphs. From here, the relevant portion and the reasoning portion will start. Page 196, second last paragraph, in regard to. Has your Lordship got it?
Yes, in regard to.
In regard to examination of evidences and documents of the parties, the Visima Village Council had taken into consideration all the documents submitted by the parties. The verification committee also pointed out in its report that The claims of the parties were deliberated by the village council during the proceeding as follows. This verification committee is without a petitioner. It is the village council and the administration. And then, number one, the claim of Tinuswili clan is operated in the village council's judgment order. Point number one, that the Kyoke forest land of Tinuswili clan was divided into 3 parts to be shared among the 3 sub-clans of Tinuswili as ordered by the 10th Deputy Commissioner GP Mills in the year 1925, namely Kyonomia, Hopizonomia, and Krahonomia. So we are questioning if it is decided basing on the GP Mills order of 1925, kindly furnish this order, because there has to be an order. And if my memory doesn't fail, as I was mentioning earlier, GP Mills in Angami area is very, very rare. They may have come, but I have seen a lot of books on GP Mills, mostly confining to the Aunakas, Simanakas like that. Sima is also Hotong, I believe. So Angami Nagas is also by Hotong. So we insisted this, and there is no records of GP Mills order. Even today also, if it is available, let them show. So in order to justify the judgment, it has to be proved that yes, this is the order passed by so and so. Now, even in the village council judgment at page 183, they have mentioned about this GP Mills case, which I have already referred to. And this order is based in the village council's order. And put the orders clearly mention about GP Mills order of 1925, and there is no record and order of that. So on the basis of a non-existent order, the order has been passed, the ambient order has been passed. Let me continue with paragraph 2. The claims of Zirikel is operated in the village council, order point number 2, that in Zirikel, in view of loan taken from Zirikel by Tinuswili clan. Further, point number 3 of the village council order states that in 1974, a land dispute started in the northern side of the forest land between Tinuswili clan and Chakra clan. Therefore, 1/3 of the southern side of the portion, which was earlier given to Zirikel in 1967, was returned to Tinuswili clan, and 1/3 of the portion of Tinuswili forest land bordering Kinau clan was given to Zirikel. It is also stated that during the time of exchange of land between Tinuswili clan and Zirikel, all the 9 clans of Zirikel, including Sikrik clan, jointly visited the spot and demarcated the boundaries. It is also observed that the Sikrik clan, while jointly visited the spot and demarcated the boundaries in 1974, along with other clans of Zirikel, is not contested by Sikrik clan during the proceeding of the case by the Visima Village Council, as well as in the appeal petition. Paragraph 3. The claims of Sikrik clan and the documents produced by the clan is operated at point number 4 of the judgment order passed by the Visima Village Council, which stated that the document signed by the seasonal secretary, the seasonal chairman and seasonal secretary, which implies settlement of forest land between Chakra clan and Tinuswili clan as forest case number 1 of 17/4/1978, received from the Chakra clan was studied, and basing on the document, the Chakra clan had laid claim over a portion of land kept it to Zirikel by Tinuswili clan over the exchange portion bordering Kinau clan's land. The Visima Village Council further examined the veracity of the document settlement dated 17/4/1978 with all the 3 parties during the hearing. The statement of the 3 parties as recorded during the hearing by the Visima Village Council is hereby reproduced below. And then the 3 points are given. The third one is our contention. Chakra representative said that they did not know about the meeting held. They came to know about it from their elders, and on seeing the document, that is the video recording and other documents, they believe it to be true. In the light of the above statements, it is observed that the veracity of the document in question as claimed by Chakra clan could not be properly established as it did not find resonance with the statements of the counterpart clan, especially the Tinuswali clan. Moreover, none of the parties present during the hearing proceedings of the Visima Village Council could exactly validate the meeting that was held to be signed the settlement document in question. Our claim of 17/4/1978 passed by the Visima Village Council was not considered at all. So our claim has been denied. And as I was mentioning, they have declined to see the video also. And subsequently came with the stand that it is not visible and it is already damaged. Next page, 198. On examination of the proceeding and verdict passed by the Visima Village Council, the concern of all the parties was taken up the case, and based on the positive response given by all the parties, the Village Council had invited for written statement from all the parties. A spot verification of the disputed area was also conducted with 5 members each from all the 3 parties. This is not correct. We were not invited during the verification. At least during the verification done by the STO Civil Jakhama along with the Village Council, pursuant to the direction of the Deputy Commissioner. The Visuma Village Council also cross-examined veracity and validity of the document produced by Chakra clan as for its case 1 dated 17/4/1978 during its hearing, and the statement of all the parties was recorded on 10/9/2022. Accordingly, the final judgment was passed on 15/9/2022, that is the Village Council, and the signatories of the verdict are the 3 kills of the Visima village. Order. After examining all the statements and claims, this court has issued an order dated 4/3/2024 calling upon the parties to appear for hearing on 8/3/2024 before this court as per schedule, and during the hearing, all the relevant issues have been deliberated and recorded, and the 3 parties had reiterated their statement claims submitted before the Visima Village Council Court. So mostly everything has been based on the Village Council judgment. 2. Accordingly, the judgment order dated 15/9/2022, that is page 183 passed by the Village Council, that has been upheld. If any parties agree, order will be shown. So that is the judgment. Now, as I was mentioning before your Lordship, the earlier order of the Deputy Commissioner, who has referred the matter to the Village Council of Visima Village, that was an ex parte order. And the Village Council has assumed the jurisdiction basing on the ex parte order. And then again, against that order, it went to the DC. And all hearing, everything was done, documents submitted before the STO Civil, statement given before the STO Civil, and the judgment has been pronounced by the DC. Yes, no doubt, at one stage or the other, DC was also involved. But the manner of exercising the jurisdiction by the Deputy Commissioner is not in accordance with law. At best, this case should be, the DC's order should be quashed and set aside, and every party may be allowed to approach the competent civil court so that the entire evidence can be adduced freely in a civil court, not in this manner by the parties, and decide the case who is right.
And what happened to the hearing before the STO Civil? Nothing happened.
No. The hearing before the STO Civil judgment was pronounced by DC.
Oh.
That is why we are agreed by that also. How can it be? The proceeding cannot be in this manner. If I hear, I should understand and pass the judgment. But somebody has heard and somebody is pronouncing the judgment. How can it be? So the entire proceeding is not in accordance with law, Lordship. Now, respondent number 3. Earlier, the number of respondents were different, but the present respondent number 3, that is, earlier it was respondent number 6. Before the paragraph, I would like to refer one paragraph. The affidavit filed by the respondent number 6 against the revision application filed by petitioner, implementing my client as respondent number 6. So that affidavit, I don't.
Affidavit of
Mr.
respondent.
Lordship, got it? There are so many affidavits filed.
Affidavit of respondent number 4.
Yes, there are so many affidavits.
4 is there, then 5 is
They have mentioned respondent number 6. Affidavit filed by respondent number 6.
Oh, yes.
Has your Lordship got it?
Yes.
I will just refer to paragraph 2. Has your Lordship got it? That I state that. Sentence starts with that.
I said that.
That I state that I, being the chairman of the Dinosweli clan of Arkel of Visima village, Kohima, when had received the notice from the STO Civil Jakama Kohima, then had appeared before him and had submitted my statement, stating in realia that so and so, so and so. So he is admitting the fact that he has given the statement before the STO Civil Jakama. And for hearing up the case, kindly turn to page 190 of the revision petition. The chairman has stated about the receipt of the summons. Which summons? By whom? Where? How? 190, page annexure 27. Has your Lordship got it? This is Government of Nagaland, Office of the Sub-Divisional Officer, Civil, Jakama, dated 14 November 2022. Summon notice. In pursuance to the Deputy Commissioner Kohima letter number 10 October 2022, the following parties are hereby summoned to appear before this court on 25th November 2022 at 12 noon. Before this court means which court? That is STO Civil, Jakama. And the chairman of respondent number 6 clan, that is now respondent number 3, he has categorically stated in paragraph 2 that on receipt of the summons I have appeared and given my statement. That is before the STO Civil. So entire proceeding was done before the STO Civil Jakama, and verification was done by the STO Civil Jakama. So, and the Deputy Commissioner, when we were summoned, the only question was whether you have given all the statement and summons, whether those are correct or not, and that is all. And we wanted to show him the video. He declined to see that. Whether the opposite party got the full opportunity or not, I don't know. So it is not just to pass an order, but Deputy Commissioner is to hear the appeal met under Rule 31 because
When you appeared before the STO Civil, all the parties appeared and hearing was done.
I also appeared. They also appeared. That is not disputed. And now, kindly come to again Impion Order, page 192. The first paragraph, last 2 lines. Last 3 lines. The appeal petition from the middle of the page. First paragraph, 4th line. In the middle of the page 192.
Page 192.
The sentence starts with the appeal petition. Page 192, first paragraph of the judgment and order.
The appeal petition.
From the 4th line. The appeal petition was taken up for examination under the provisions of Rule 31 of the Rules for Administration of Justice and Police in Nagaland. So, DC has conducted the hearing in terms of Rule 31 of the rules. So, what Rule 31 of the rules says? that will be relevant. So kindly come to the rules. I would like to refer to the Rule 31. Just, Lordship, for easy reference.
It's here.
Just first paragraph only, Rule 31. Lordship will find it page 38 in the book authored by Z. Angami. Page 38, Rule 31, Clause 1. The Deputy Commissioner, after hearing the parties to the appeal or their advocates shall pronounce judgment in open court, like that. So, rule says to hear the parties. We did not get a fair hearing before the DC. So, Lordship, entire proceeding has been conducted in a biased manner. And no opportunity was afforded before the Deputy Commissioner in the earlier order, that is 1/7/2022. It is an ex parte order, admittedly. And the Village Council has heard the matter based on an ex parte direction of the DC. Therefore, the very foundation and basis itself is wrong. And the order which the Village Council has passed, that was the foundation and basis for the Deputy Commissioner to pass an order. So he has not applied his mind, he has not exercised anything, just because there is a legitimate judgment by the Village Council, which was conducted on the basis of an ex parte order of 1st July 2022, passed by the Deputy Commissioner. The order was passed. So the consequential order, that is 3/4/2024, the present impugn order, has the genesis and basis in the ex parte order of the DC, which was passed on 1st July 2022. That is one solid point. And the other is the forest case number 1, dated 17/4/1978. We have insisted for looking at the video that was declined. Later on, they said that it is damaged. So that document has been ignored. The map was also ignored. So, number 3, which is very vital, is the order of GB Mills of 1925. There is no record has been produced. But basing on that, the direction has been passed. Therefore, all the 3 orders passed by the Deputy Commissioner should be quashed and set aside. And if any party is accurate, they can approach the civil court for proper adjudication in accordance with law. That will be my short summation, Lordship. Otherwise, there are secret history of facts. I need not go to all these things, because it is a civil revision.
We need not go into that.
Yes, Lordship. Much obliged.
Yes. Yes.
Yes, my British Lordship. There are some document judgment which they have supplied to us are not very readable. So I may need the assistance of my colleague to read out some judgment. Because photocopy supplied to us are not readable, some order documents. My Lord, my learned senior friend has pointed out all other things except few. I'll just give short. I have prepared a list of date so that at the time of writing the order, it will be correct and it will be as part of the document. So, in Vishama is a biggest village under Southern Angami. And under Jerry Kell, I represent Jerry Kell. Under Jerry Kell,
You are representing
Jerry
Jerry
Kell,
Kell.
Jerry
Okay.
Panchayat.
And the others?
They are for village chairman. Actually, village chairman should not be a party because it's a court, good or bad. But I have implemented a DC party that dropped. Chairman is still there. I represent for Jerry Kell. As after the amendment of the post I'm
R2.
R2. Under Jerry Kell, there are 9 clans, big Kell. And Zukruk clan as well as Kenau clan are all under Jerry Kell. They are part of Jerry Kell. That much, if the Zoma court understand, then it will be easy for the court to understand.
The petitioner as well as this R3, they are all under Jerry
Under my Kell. I represent the Kell, Jerry Kell. Kenau clan as well as Zukruk clan, they are under Jerry Kell. They are clan under my Kell. And I'm just giving the gist of list of dates so that it will be easier for this court to understand. I'll just read this out. After that, I'll come to my short affidavit. Petitioner, Zukruk clan file complaint to respondent number 5, it's me, R2, before R2 Jerry Kell, to settle land dispute against Kenau clan. Within bracket, both Zukruk clan and Kenau clan are from Jerry Kell of Visoma village. The date of filing the complaint was 17/12/2018, NHA 3, page 32, 33. I'll just read a short few documents only. Page 32. Page 32. Page 32. My lord, reverse side, page 33 is the translated copy. To the chairman, Jerry Kell, Panchayat Visama. And I just put this to Lordship's mind. Panchayat is a court, and it has original civil jurisdiction as per Rule 1937. Yes. Conjoint reading of Rule 23, 24, Rule 31 says that Panchayat is an original court having its original jurisdiction under Rule 1937. So therefore, when there was a land dispute between the 2 clans, they came before the Jerry Panchayat, and this is the complaint or plaint filed by Zukruk clan. Appeal to the chairman Jerry Panchayat Visema. Subject: appeal for hearing against encroachment of Zukruk forest land by Kenau clan. Sir, as cited in the above mentioned subject, we bring forth this letter before you that the Kenau clan is encroaching our forest land between Dulazi stream and Sukrol stream is initiating certain activities. Therefore, we request the Jerry Panchayat to look into this matter and resolve the issue accordingly. So this is how it originated. Now, my lord, are coming back to next list of date 2. Jerry Panchayat decided that the disputed forest belongs to common property of Jerry Kell, Visema, and not clan property. I'll just show. Page 40. Page 40. This is correct, no? NHF 5. NHF, page 40. Page 40. Page 40, 44, continuation. Page 40. This is the order passed by the Panchayat. Page 40. NHF 5, page 40. May I read it?
Yes.
Office of the Jerry Kell Panchayat Viswama, dated 27 February 2019. On 16 February 2019, the Panchayat heard the forest land dispute case arising between Tsukra clan and Kenao clan. That the submissions were made by both the parties, and on further perusal of records, the Tsukra clan has brought forward a material in record of earlier land dispute settlement between the Tenusela clan and Tsukra clan, and it appears that the Jeri Panchayat stood witness of the said settlement. But upon query as to whether any member has knowledge of such event, the Jeri Kel members claim ignorance of the said issue. Therefore, owing to the necessity of inquiring the other party, that is Tenusela clan, the matter could not be resolved on the said date. Subsequently, the Tenusela clan, my lord, these Tenusela clan is another Arkel. Arkel has denied, subsequently Tenusela clan has denied to have had any boundary dispute settlement with the Tsukra clan, and that no such written record has been made. Therefore, the 7 clans of Jeri Panchayat have arrived into a conclusion that the land in dispute belongs to Jeri Panchayat, since the aforesaid forest land from the stretch of Suekrol stream to Zuladzur stream to the mountain top has been gifted by the Tenusela clan to the Jeri Panchayat. Therefore, you are directed not to raise any more issue in regard to this forest land belonging to Jeri Panchayat. If any party intends to bring up the issue of defaulting, this order will be excommunicated from Jeri Kel. This order signed by all tribes. Now, another here important aspect is this order is never under challenge. It still remains. I'll show that. This order is never under challenge by the present petitioner. So therefore, this order still remains. Now, as per my list of dates, 3, petitioner Tsukra clan filed appeal to Chairman Judiciary Board Vishwama against Jeri Panchayat decision dated 27/2/2019, page 42-43. Page 42-43. My lord, the English translation copy is page 43.
So the petitioner appealed.
Yes, the petitioner, Tsukra clan, filed appeal before Judiciary Board, Visamoy village. Subject appeal so and so. Sir, as cited in the above mentioned subject, we bring forth this letter before you and before you that the Kenao clan, by encroaching our forest land between Zuladzuk stream and Suekrol stream, and is initiating certain activities at the aforesaid land that are aggrieved by the verdict passed by the Judiciary Board. Therefore, request the village council to look into the matter and resolve the issue accordingly. This was filed before the address to the Judiciary Board. And your lordship knows very well, under the rules for administrative justice and police in Nagaland, there is no nomenclature, there is no court called by nomenclature called Judiciary Board under the rules 1937.
Village council is there.
No, village council is there, but address Judiciary Board. But I'll come to that. Even then, how they have not pursued this matter? Because this was not decided, this was not under appeal, under challenge at all. Now, therefore, I have paragraph 4 in my list of dates, serial number 4. The nomenclature called Judiciary Board of Visamoy village is unknown to the law, therefore, Tsukra clan did not pursue the matter. 5. After a gap of 1 year, 7 months, almost, Secret Clan filed a fresh complaint, not appeal, fresh complaint against Tenusela clan of Arkhel, Vishama, which was not a party to earlier case over a forest dispute before SDO Jakama. Now this is the most important part. Before Jericho, the only parties were Secret Clan and Tenusela, Keno clan. They are under Jericho. Now before SDO, I am not a party there. Then Keno clan is not a party there. Only Secret Clan has made only Tenusela clan of Arkhel of Visema village. I'll show that document, page 78, my lord. Whether I'm just giving the correct facts or not, it will be borne out by record. Page 78. Page 78. NHR, I don't know. NHR, page 78 anyway.
Yes, letter to SDO Civil.
Yes. Now look at the heading. Prayer for court hearing for an impasse against a forest land dispute between the Secret Clan and Tenusela clan of Visema village. Jericho is not a party here. I'm not a party. Keno clan is not a party. Tenusela is a new party. That's why it's a new suit under the law. It's a new suit under the law. It's not an appeal. It's a fresh. Therefore, SDO has, generally, under the law, SDO has no original jurisdiction to try this. This is what I'm trying to say. How can SDO entertain this civil suit? Having no jurisdiction, having no original jurisdiction to take up any plain title suit. DC, SDO, all its subordinates are appellate forum under Rule 31. If Lordship read Rule 31. DC and his deputy assistant and all other assistants are appellate court. Any judgment arising of Dobashi's village court, appeal has to come before DC or to his assistant, which includes SDO. SDO is assistant deputy commissioner. This is my case. Therefore, how can
Panchayat also does not figure in the
No, it's here. I'll show, my lord.
Where is that?
I'll show. If your lordship reads,
The rules recognize only village council.
No, lordship may kindly come to, I believe we have the same, this one.
Yes, yes.
Page 28. Page 28.
Yes.
Page 28, Rule 24. Read with 31 also. May I read Rule 24?
Yes.
Mauzadars, Gaumburas, headman of Khels, Panchaya Khel, the Jeri Khel, Jeri Pandisi Khel. So they have the original jurisdiction to entertain any claim for the decisions of title. Then read. Then Rule 31, conjoint reading of Rule 31 again. Lordship may kindly come to 31 also.
Yes, yes.
An appeal shall lie from the decisions of the Mauzadar, Gaumbura, chief, headman of Khels. Khel is always having original jurisdiction to try. So any judgment arising out of all these coordinate courts, the appeal will lie to the deputy commissioner or his assistant. SDO is assistant in terms of law, Rule 37. 1937. So therefore, this is the crux of the matter. How can Secret Clan came directly to SDO, which is an appellate authority under Rule 31, to settle the dispute involving immovable property? Number one. Number two, before the Jeri Khel, the parties contesting against each other are different. Here, before SDO, Jeri Khel is not a party. When Jeri Khel claimed that this belongs to all of us, common property. Number two, when Kenao clan was the party in Jeri Khel, now Secret Clan has conveniently avoided Kenao clan also before SDO. They have dragged a new name called Tenusela clan from Arkhel. So therefore, it is always a new civil suit before a court having without original civil jurisdiction. Just to make my point clear. Now, coming to next page, my list of date, my 7. Jerry Kell filed appeal number 52 of 21 against this judgment dated 12/03/21, passed by SDO Civil in number so and so. Appeal number so and so, filed on so and so. Now, page 107. Is the order passed by the SDO without having any original jurisdiction. May I read it, my lord?
Yes.
107. Order passed by the SDO. Government of Office of the Subdivision Civil SDO so and so. Party. Party is important, Your Honor, here. Party. Sakra clan Vishamai village versus Tenosala clan, who is a new party. Tenosala clan was never a party before Jericho, never a party before village. Dated 12 March 2021. Now, judgment. Whereas this court has thoroughly examined all available evidences presented before the court by the clan of Vishamai village. And whereas the Vishamai village council, in spite of being given sufficient amount of time, has failed to produce any argument, evidences contrary to the case presented by the Sakra clan. And whereas Jerry clan, Vishamai village, was found guilty of trying to appropriate to itself the ownership over land over which it has no rightful claim or entitlement whatsoever. And whereas the Vishamai village council was also found guilty of taking a partisan stance on the case under dispute by willfully refusing to take cognizance of the glaring material evidence available on the case, thereby allowing a particular clan in the village to be subjected to undue discrimination and harassment. Now, therefore, after thorough examination of all material facts and evidences on the case, the following judgment is passed for strict compliance of all concerned. 1. Sakra clan Vishamai village is hereby recognized as the rightful and legitimate owner of the land in question, stretching from so-and-so to so-and-so. No other khel or clan should henceforth claim ownership over this land or carry out any activity on the particular stretch of forest and land without the knowledge and consent of the Sakra clan Vishamai village in future. 2. The arbitrary order passed by Jerry Kell Vishamai village excommunicated so-and-so. This talk about excommunication. Clan from the village without any valid reason is hereby declared null and void. Fine. Now, as I have pointed out, before SDO, parties are totally different. I'm not a party there. Kenau clan is not a party. So therefore, the order passed by SDO has no binding. But after coming to know,
this is pending on relying on the letter written by the petitioner.
Yes.
This is
very much.
That letter,
Yes.
letter of 12/16/2020.
Correct. Yes. Based on that, this judgment was passed. So therefore, we are saying this is ex parte order. How can you pass any order without making me as a party? I'm not a party to that. Kenau clan also not a party to that. Party is totally now Sakra clan and Tenusala clan only. Tenusala clan is not from my khel, they are from our khel of Vishamai village. So this is how things went wrong before SDO. Without making us necessary party, how can he pass any order at my back? Now, my lord, according to my list of days, number 8, against that SDO order, Jerry Kell, DC recommended the matter to VC to try the case, including Jerry Kell, de novo under section 4 so-and-so. However, it was without setting aside SDO order so-and-so. Now, against the order passed by SDO, because SDO order says that the entire land will be given to the Sakra clan without making us necessary party. So we file appeal before the DC. Judgment is page 120, 120, 121. Yeah. Now, this is the order passed by the Deputy Commissioner after receiving my appeal, because I have filed.
So you also didn't make the petitioner a party here?
No, my lord will
In the
see.
appeal? Appeal before this?
No, definitely we made them party. Show me my appeal.
Order dated 27,
I have
4.
made. I have the petition copy also. No, it's their file. This morning I show you.
Maybe made a party, but what about summon notice?
That I have made them party.
Because their specific allegation is that this is an ex-party order.
My lord will see. My part, what I have done is, this is I have filed this on 12/4/2021, appeal. Then parties are secret clause number 1. I am the appellant. Secret clause is number 1. Tenusala clause is number 2. So that I have made all of them party. This is my appeal. So this is in my appeal. I have made them 1 and 2. I have not excluded anyone, but in the case of in the secret clause before, as though they didn't make
Okay, you're
Yes.
not the party there.
Yes.
But
That-
here, whether
yes.
proper notice was given to the petitioner or not,
That
while hearing this appeal by
for
you.
this, I'm coming to that last part, because my learned friend has made a long argument that DC had not given fair chance of hearing. I remember, if I remember correctly, when DC was necessary party initially. Later on, court said, how can you make DC necessary party without court? Otherwise, DC had filed affidavit. I have a copy. DC has clearly stated that no, on such date, I have issued notice. Hearing was so and so. DC has filed affidavit in the present case. Present case.
Saying that notice
Yes.
was issued.
Yes. So therefore, if this court desire to know, then record can be called after argument. No problem. Can be reserved. Record can be perused. Because I cannot submit anything on behalf of DC. Because DC has filed affidavit in this case before he was dropping. That I have a copy filed by DC, because DC gave to all of us. We exchanged the pleadings. So therefore, DC also make clear that, especially for the final order, what I don't want to say anything on record. My learned phrase is that the DC did not give in fair opportunity of hearing, but DC initially had given specific dates on such date, on such that someone was issued to all the parties. Hearing was done on so and so. Judgment reserved. After judgment reserved, judgment was pronounced. So therefore, I leave it to Judicial Court. Otherwise, I feel that it will be proper if record also can be called for in this case. Now, my lord will see, by this order, 27 April 2022,
It was sent to the village
now,
council.
therefore, that's what I'm coming. Court did not give any finding. Simply, no, yes, this order without making Jerical and Kenokland a party, and even this ex-party, this is wrong. So therefore, send back to village court, which has original jurisdiction. That much. No finding. But what happened? At the time of sending back, remanding back to village council, the order of the SDO was not set aside. So therefore, I came before the DC. No, unless you set aside for the time being, stay there. Otherwise, this village council will have an impression that still that is your SDO order is binding. So therefore, when I come with review petition, court simply allowed, and after that, DC had given all the power authority under the law to the village council to decide on merit after hearing parties. Now, my lord, coming to 10, 9, 8, I think I have covered. So coming to 10, DC allowed the review petition and set aside the SDC till further order or pending disposal of civil suit in the village council. This is page 122, NHA 21. So, therefore, as I have made my submission, DC did not give any finding in these orders, simply remanding back for de novo trial. Now,
But see, 1st July order also, the parties are not heard.
correct. No, that's what, my lord, I'm saying. These two orders are more or less 27-4. First 7 also same, because remanding. First 7 order is
not only remanding, but here
yes.
The effect of this order is that the ex-party order of SU Civil was set aside.
Correct. I pray for the full
Without
review.
hearing-
Yes.
without hearing the
Because now after setting aside, unless it is set aside, my prayer was, in review, my prayer was, Your Honor, I told Your Honor, unless you set aside for the time being, how village council will decide against the decision? Unless it is set aside. So after hearing me, it was set aside.
But while setting aside, doesn't it affect the right of the other party also? Without hearing them, can such an order be
Record can
passed?
be called. Record can be that. Now that's what my submission is. It is nothing but just remanding back. So now all of us, Sutri clan, Kenau clan, Tenusala clan, Jerry Kel, all four of us have to go to the village court and establish our title there, as per the law. We have to go and establish our title. That much, only that much the DC has done. So now the entire thing on merit, it will be decided by the village council. Now I am coming to village council's decision. How fair, how correct it is. 11, as per my list of date, 11, I'll come to page 183. Whether the judgment of village council fair or not. Like I said, the documents are blurred. Let me see, I'll try my best to read out. Page 183.
183.
I'll just read out whether it is fair or not. Because this is finally it has culminated to this. This is Judgment Village Council. May I read it, my lord?
Yes.
Yeah. Reference to Deputy Commissioner Kohima number so dated 27/4/22 and 1/7/22. The Village Council held its hearing on 10/9/22 to settle the issue in regard to forest land dispute at Duledze and Swekrol to so in between Sutro clan, Tenusal clan, and Jerry Kel. All three were all heard. The village council held its meeting on 12/7/22 and decided to ask both the parties whether they agreed to settle the case under village council jurisdiction. Accordingly, all the three parties replied this call in positive. Again, the village council held its meeting on 20/7/22 and decided to invite all the three parties to submit their statements in written separately. All three parties had submitted their written statement in the village council. On receipt of their statements, the village council held a meeting on 7/8/22 and decided to verify the disputed spots. Accordingly, the village council members, along with 5 members, each from the 3 parties, went to the spot. All went to the spot and verified the disputed area of the forest, which is in between Duladze and Swekrol as per the statement of Sutro clan, and it is in between Duladze and so as per the so Zerkel and Tenusala clan. Though the area and the streams are the same, within bracket, these 2 streams join together to become a bigger stream, and from there the stream is called Swekrol as per the statement of Jerikel and Tenusana clan. On 11/8/22, the final hearing was held under the chairmanship of Village Council Chairman at Pavo Panchayat Hall on 10/9/22, where 8 members from each party attended the hearing. Firstly, the chairman informed all the 3 parties of the rules and regulations of the following during hearing. The statement of each party was read by a member of each party and were being given time to speak on the subject which were needed to be added beside their statements. Subsequently, questions were raised to both the parties and heard. The village council, after hearing both the parties, the following observations were made. 1. It has been perceived that the judgment of the then Deputy Commissioner so-and-so, case number so-and-so, which was ordered to divide the so-and-so, the national clan into 3 parts, sharing among so-and-so. These are the 3 names. Then, continuation, next page. In the year 1967, 1/3 of forest land on the southern side was given to Jerry Kell as gift deed in lieu of loan the Nuswala clan had taken from Jerry Kell. 3. In the year 1974, the forest dispute arose in the northern side between Zukra clan and Tenusala clan. However, the leader from both sides of Tenusala clan and Jerry Kell mutually agreed to exchange the forest land, and accordingly they agreed to exchange 1/3 of the southern side given to Jerry Kell earlier to be given back to Tenusala clan, and 1/3 of the east side of the Tenusala clan's forest land bordering Kenau clan of Jerry Kell was given to Jerry Kell. During that time of exchange of the forest, the members from both sides of Tenusala clan and all 9 clans of Jerry Kell, which include Zukra clan, jointly visited the spot and demarcated the boundaries. 4. A document which was a case settlement between Zukra clan and Tenusala clan as forest case number so-and-so 1978 was received from Zukra clan. From their statement was studied. According to the judgment as found, some part of the gift deed portion to Jerry Kell by Tenusala clan are to be under Zukra clan forest land. In regard to this judgment, all the 3 parties were asked during question are: 1. Jerry Kell representatives said they did not know about this settlement. They only could come to know about this judgment after Zukra clan brought in the case presently. 2. Tenusala clan representatives say that they did not know about it. They only could come to know after seeing this document from Zukra clan in this present case. 3. Zukra representatives say that they did not know about the meeting held. They came to know about it from their elders, and on seeing the document, they believe it to be true. So this is the judgment. Now, next page is the judgment, decision. The village council, after examining the statement and hearing the parties, decided as follows. 1. A copy of the judgment forest number 1 passed by sessional chairman and sessional secretaries on 17/4/1975 is not valid as per submission at para 414243 of the observations. 2. The disputed area ought to belong Jerry Kell, in which the Zukra clan has also a share in it among the 9 clans of the cave. 3. Henceforth, no rude words, slandering words, and any undesirable words or action to provoke any member of 3 parties on this issue, failing which the village council will take action as may deem fit. Signed by all this. So now, going by the decisions of the village council, it appears that the principal nature has been done to all of us, collected all the material evidences available from all parties.
They're saying that they did not go for the verification.
But then, whom to believe? This is the judgment. So against this judgment, they went to Deputy Commissioner. That's what I'm coming. Now,
and what about
Lordship,
JP Mills?
there is one clarification there. Sorry for interruption. I hope my learned friend will agree with. Spot verification, there are 2 types. Once, after the DC remanded back to the village council, verification was conducted. During that time, we were also invited.
By the village council?
Yes, and we have participated also. That is correct. But
So
after the village council has passed the judgment, we filed an application before the DC.
Yes.
During the pendency of that proceeding, another verification was conducted by the STO, headed by STO, where the village council was invited, and they have gone to the spot and verification was done. During that time, we were not invited. So there are 2 verifications. One verification During the trial before the village council, we were also invited, yes, we admit that. But during the verification under direction of the DC, we were not there. We were not invited. So that should be very clear. Sorry for the interruption, but to set the facts correct, Lordship, I want to place.
Yes.
I am on village council decision. So as far as village council decisions concerned, everyone has admitted that we all have taken part for sport verification. Now against the not happy with the decisions of the village council, not happy with the village council, not appreciating the village council decision.
Then what about this JP Mills order? Was it produced before the village council?
That they have, I don't know. I have no idea about. Because village council, that has been cleared by village council. Yes. Whatever we tried, we have done our part. Now, then, against this village council decision, they have come before the deputy commissioner.
Yes, 188.
188, nah? 188. 188, they have come before deputy commissioner. This is the application filed by them. Later, dispute over forest between Tenosala clan, Sakrat clan, and Jerry and Zed Kel. Now, initially we were not there. Now we have been included now. Yes. Before SDO, they didn't include Kenau clan and Jerry Kel. Now Kenau clan and Jerry Kel has come. With reference to the order dated so-and-so 1722 and number so-and-so dated 3822 on the subject stated above, in which Visama Village Council was directed to take up case within the time frame contained in this order. We would like to bring to your notice our grievances consequent upon these orders. On a verdict issued by Visama Village Council number so-and-so dated 15/9/22 enclosed. That's upon receipt of your copy of the same, it must have apparently become clear that the verdict was lopsided and without watertight proof due to several reasons as may be stated under. 1. Visama village comprises 4 khels, namely K khel, P khel, R khel, Z khel. The land dispute involves Tenosala clan from R khel, Sakrat clan from Z khel, and Z khel, who are beneficiary of a gift by Tenosala clan. As such, members from 3 khels deliberated on the statement made by the parties, but predictably signatories of the verdict belong to 1 khel, only which goes to show that a consensus was not ever arrived at. K khel, P khel refused to sign the document. 2. It can be summarized from the statement of the other parties that Z khel should not come into picture as a contender, since it is an admitted fact from themselves that it was a beneficiary of a gift deed. The land in question is contested as primary owner only by Tenosala and Sakrat clan, for which reason the nature of deliberation should change course. To let it or not become a common property as contained in the verdict will become clear only once contention is settled. 3. Very conveniently, all the reasons presented to justify the verdict arrived at have ignored our side of the claims, which we supported with solid evidences. For example, names of some people who had sought permission from our elders to extract forest product from the area as recent as less than 10 years back. The same people blatantly denying their act. 4. From the way proceedings took place in the hearing, it is very unfortunate that the present day generation is ready to alter even little history that was recorded in written, which was passed down to us by elders fortunate to have had some writing knowledge, otherwise orally done those days. If required, original copy is still in custody, which may be put to test to prove its authenticity. Putting to doubt even such a rarely available record only cast serious doubts on the intentions and sets a bad procedure for posterity. Our claims have been thoroughly perused by the SDO Civil Jakhama earlier too, when his office took up the matter and judgment also issued enclosed. But following your order that the village council should try the case afresh, we agreed to the request. All agreed to the request. But hugely disappointed by its outcome. The verdict does not even make mention of any opportunity of an appeal if the same is not accepted. Our clan members have already been subjected to various forms of rejection owing to this case. Therefore, so and so. So this is their appeal before DC. Now we all had contested before village council, and thereafter, now being agreed, since they did not appreciate, they have come before that DC, and DC has passed this order. Now, yes, my friend has pointed out, but see, there are a lot of argument that there was discrimination arbitrarily. So I want to read out the judgment part of DC, so that the facts should be known to this lower court. Very blurred, huh? Now I'm coming to the impugned judgment. Impugned judgment now, the judgment which is under challenge.
It will be a repetition only. I have read the entire judgment.
All right, so then I'll not read. Okay. Now then therefore, now in the case, in the present case, as I have pointed out, Deputy Commissioner has given all opportunity to everybody. If Lordship will, it will be on the record. Deputy Commissioner also has filed affidavit saying that he has given opportunity to everybody. Date, even specific date he has mentioned. We have got also a copy here. Now, based on what I have prepared the list, I'll just read out my affidavit. The facts. I'll just read out my affidavit. Affidavit filed on behalf of now R2. Earlier it was R5. Earlier it was R5, it was R2 now. It was filed on 6/11/2024. Presently now it will be R2, but earlier it was R5. R5. Yes. I'll just take.
Filed on 6/11.
Yes. Page 2. I'll just start from paragraph 2. Whatever I have pointed out in the list of date, I have explained a little bit here. Just 2-3 paragraphs here. Paragraph 2. That I say that being the chairman of Jerry Kel Panchayat, by looking on the record, can say that the then chairman of Jerry Kel Panchayat on 17/12/2018 had received an application in the form of appeal for a hearing against the allegation of encroachment of Sakra clan by Kenau clan. The said application appeal was filed by 2 persons, namely Visol Sakra and Visaho Sakra, and was registered as case number 01 of 19, and accordingly notices were sent and served upon the parties asking them to be present and show cause on 16/2/19. May it continue? Paragraph 3. That the parties of case number 1 of 19 appeared before the Jerry Kel Panchayat and submitted their statements. The complainant, that is Sakra clan, on that date claimed to have produced a photocopy of document of the year 1978, that is dated 17/4/1978, wherein they also claimed that the said document it was decided that the disputed land belongs to Sakra clan, with their further contention that the Jerry Kel Panchayat was a witness to that document. The said document is Exhibit Annexure 4 of the CRP 12/24. On its bare presumption do not show the signatures of any of the member of the Jeri Kel Panchayat. Rather, it depicts the signature of sessional chairman and sessional secretary at the end part of the said document, and which said post cannot be expected to be and or was ever in existence of Jeri Kel Panchayat at that point of time, and hence its integrity was doubtful. Further, the rules contained in the Rules for the Administration of Justice and Police Nagaland 1937 nowhere contemplates any such post like that of the sessional chairman and secretary, so as to put any reliance on Annexure 4 and its signatories, and hence the same was disbelieved for want of jurisdiction. Be that as it may, as Chakra clan is a clan of Jeri Kel Panchayat, and land under dispute were once upon a time belonging to Tenusana clan of Ratcha Kel and not of Kenau clan, who in the year 1968-67 had gifted their 1/3 land to Jeri Kel in lieu of the loan taken by them from Jeri Kel and returned. Hence, the Jeri Kel Panchayat by perusing the application/appeal dated 17/12/18 decided the same on 27/2/19, that is by Annexure 5 of the CRP number 12/2024, and as such, there is no lacuna and or lapses on the part of the respondent 5 while passing such order. It would not be out of place to state here that the record of CRP 12/2024 also reveals that as against the order dated 27/2/19 passed by the Jeri Kel Panchayat, the petitioner, that is the Chakra clan, if at all aggrieved, would have preferred any regular appeal to any appropriate forum, but they, instead of doing that, went on to Chairman Judiciary Board of Visama Village Council, White Annexure 6, dated 19/3/19, alleging the same dispute against the Kenau clan, and when the matter was not materialized in their favor by the Judiciary Board, Visama Village, then after a gap of 18 months, the Chakra clan approached the subdivisional official civil Jakama via their fresh letter dated 12/10/20, and wherein for the first time they made Tenusela clan as party instead of Kenau clan. The response number 3, SDO civil Jakama without making any proper approach to the petitioner's petition. The petition made by Chakra clan against the Tenusela clan had decided the matter ex parte, White Order number 12/03/21, Annexure 17 to the CRP 12/24, and that too without having any original jurisdiction to decide the same. Further, the response number 3 also did not make any effort to see as to whether the Jeri Kel is a party to the said proceeding or not, and decided the matter ex parte, but by making reference to those matters which had already been decided by Jeri Kel Panchayat. 4. That the Jeri Kel, on coming to know that the said ex parte order of SDO civil dated 12/03/21 preferred an appeal before the response number 2, that is Deputy Commissioner Kohima. The appeal was heard, and when the Deputy Commissioner had found that the order of SDO civil is without jurisdiction, then the same was remanded back by his order dated 27/4/22 to the Visama Village Council as contained in Annexure 21. Be it stated that as the matter was only remanded back to the response number 2 to the Visama Village Council by the response number 2 to the Visama Village Council, and that too without setting aside SDO civil order dated 12/3/21. So the Jeri Kel preferred a review petition before the Deputy Commissioner, and who on being pleased had set aside the ex parte order of a subdivision of official civil Jakama by his order dated 1/07/22. 5. That the Visama Village Council, on receipt of the record from the Office of the Deputy Commissioner, together with the cancellation order dated 1/7/22, took up the case and issued notices to the parties, and who after their appearances tendered their statement, and based on which the Visama Village Council passed an order to make spot verification, and only after verifying the said spot passed its order on 15/09/22, holding entirely that the disputed land ought to be belong to Jeri Kel, in which Chakra clan has also a share in it, among the 9 clans of the camp, it would not be out of place to state here that the decisions of Visama Village Council is akin to and in consonance with the decisions of Jerry Kel Panchayat given on 7/2/2019, and hence there is no illegality and the revision petition is required to be dismissed. 6. That the decisions of Visama Village Council was not appreciated by the Chakra clan, and as such, the said clan filed an appeal before Deputy Commissioner Kohima, and the same was registered as appeal number 1 of 22, wherein the statement were given by all the parties in writing. Based upon the said statement, and also after perusal of this case record, and upon hearing the parties, the Deputy Commissioner, Response number 2, was pleased to dismiss the appeal number 1 of 22 on 3/7/24, and thereby upholding the judgment and order of Visama Village Council pronounced on 15/9/2022. In this context, it would not be out of place to submit that the order of the Deputy Commissioner is neither illegal nor perverse or without jurisdiction. So, perversity comes only when the finding is not in conformity with the evidence. So, therefore, Deputy Commissioner has come to a finding that the decisions of the Village Council is not perverse. And therefore, Deputy Commissioner has upheld the decisions of the Village Council. Therefore, the decision of Deputy Commissioner, after examining all the records and the decisions of the Village Council, has upheld that is not perverse also. Now, the present case is a revision petition. Revision petition is normally filed when there is any perversity in the evidence, and or when the lower court have committed any jurisdictional error, and as such, both are missing in the present case. Therefore, the present case is not maintainable and is required to be dismissed. Now, I'll just show, in this case, my lord, the 2 courts in the lower court, the village court, and also this Deputy Commissioner's court, they have concurrently passed. They have concurrently given a finding of facts as well as law also. So concurrent finding of facts as well as law, if that is established, the apex court as well as our own high court also held that if it is a case of concurrent finding of facts as well as law, then in that case, high court may not interfere with the concurrent findings of the 2 lower courts. I'll just show. My lord, this is reported in year 1996. When there is a concurrent finding of facts as well as law, high court need not interfere with the decisions of the lower court decision. Year 1966, Supreme Court, page 3521, but the relevant paragraph is paragraph 10. Paragraph 10. May I read it? Just one small kata. Three sentences.
Where is the court's copy?
Yeah, I'll just give this one. I'll just give it this one. Paragraph 10. Just 3 sentences. So I just want to show the principle. When it is a case of concurrent findings of facts as well as law, Supreme Court held that High Court need not interfere in judgment.
PIR 1996.
Yes.
Supreme Court 3521. Yes. Para
10.
Yes. Please read.
Yes. My lord, that is the only available record I have.
Oh.
Please. Just 3 sentences. So I thought.
Para 10.
Yes, para 10. Just to the point of it. Because in the present case also.
Yes, normally, if there is no perversity or
Yes,
illegality.
correct. So in my case today, I'm saying there's no perversity because the village council court, after giving opportunity to all the parties, submitting written statements, went for spot verification, everything after collecting all these available material evidences from all parties, village council has given its finding that look, this become common property including you also. In this case, they are claiming exclusive possession of the land by separate clan. But Jerry Kelly said, no, you are also part of it. It's a common property. This was in 1966, it was given to us by Tenusana clan from Arkel. Because they took loan for one high court case that time. So Tenusana clan could not pay money. Those days, it seems, the narration, they told unaware, but it seems there is a record in high court also. For another case, Tenusana clan took some loan, those 60s. So they could not pay, so therefore they have gifted this to Jericho in 1960s. So therefore, how can you claim as yours alone? This belongs to all of us, you are also there. This is our common property. This is what Jericho stands. And after collecting all the material evidence,
And petitioner is also under your care.
yes, all of us, we are saying, we are one. Common property, don't say this is yours. Because it is not that you have any document to show on that. Because for that, if as far as gift deed is concerned, if Lordship may kindly see page 76, gift deed is already enclosed in the revision petition alone itself, page 76. How Tenusana clan had gifted to us, taking loan from us those days. May I just read it?
Yes.
This is type copy, gift deed. We, the Tenusana clan, having have our land at so and so, which extends from Dulatze till so and so. When there arose a dispute around the year 1963-67, whereby a case was filed before the Honorable High Court, Gauhati High Court, during which Jerry clan had extended their moral and financial support to us. Therefore, our ancestors had verbally gifted 1/3 of our land to the Jerry clan towards so-and-so, located at so-and-so. Therefore, the Tenusala clan authorized the elders, namely so-and-so, so-and-so, on 10 October 1967 to sign on behalf of the clan. Thereafter, in the year 1974, the elders of Jerry clan and Tenusala clan, on consensus with the 1967 gift, had finalized and completed the gift to the Tenusala clan to Jerry Kel, and the same have accepted the gift. We signed this gift deed on 1st November 19 so. So in a layman, there's a village style, they have done this, at least piece of evidence. So therefore now when the village council had taken up the case, that's why I keep saying there's no perversity here. Because the judgment is not against there's not contrary to evidence. If the judgment is contrary to the evidence, it will be perverse. And if there's perversity, obviously, this Honorable Court has the power for judicial review. But in present case, it is absent. That is what I'm saying. Now, my Lord, there was another similar case by this Supreme Court on this. If there is any concurrent finding of fact as well as law, Supreme Court has passed order this is reportable 2025. Civil Appeal number 5131 of 2025. Civil Appeal number 5131 of 2025. I'll just give the judgment. The relevant paragraph is paragraph 33. Similar, 23. Similar principle that if there is any concurrent finding of the two lower courts' decision, 23, paragraph 23. Just 2-3 paragraphs. I'll not take. petition. So therefore, in my humble submission, to sum up, the petitioner in the reviewing petition has not made any case to show to the court that there is perversity in the order passed by village council as well as passed by the deputy commissioner on 3/7/24. Therefore, the revision petition is liable to be dismissed due to lack of merit of the case. Much. I am for the respondent number 2 as per the after the amendment. Much of it.
May it please, Lordship. Lordship, I'm for respondent number 3, Denusile Glen. Lordship, if I'll be short and brief, Lordship. If I may be allowed to read out the relevant paragraph from my affidavit in opposition. Paragraph 2. Filed by earlier, it was respondent number 6.
Earlier R6.
Yes, Lordship. It's page 2, paragraph 2, just a relevant paragraph, if I may. That I state that I, being the chairman of the National Clan of Arkhill of Visama village, Kohima, when had received a notice from the SDO Civil Jakama, Kohima, then had appeared before him and had submitted my statement stating inter alia that sometimes in the year 1965 to 66, my clan had taken loan from the Jericho and when could not return the said loan amount, then had gifted 1/3 of their clan land to the Jericho clan, and in that way, when the land which once upon the time belonged to us as gifted to Jericho clan, and since then till now they are in occupation of the said land. Lordship, here just my humble submission is that now we have our clan had gifted the 1/3 of the land to the Jericho clan, Lordship. And since then, till now, they are in possession, they are in occupation of the said land. Therefore, Lordship, here my humble submission is that the Jericho clan is the occupation of the disputed land. And the rest, Lordship, I'll adopt the submission of my...
clan is an occupation.
Lordship.
Jericho is an occupation.
Lordship. And the rest, Lordship, adopt the submission of my senior, who is representing the respondent number 1, Lordship. Sorry, respondent number 2.
You did not say anything about the contention of the petitioner that hearing was done before SDO Civil, but judgment was given by DC.
My Lord, I cannot go beyond the record. It's very clear on the record. SDO, DC has filed affidavit. Specific date he has mentioned. I have record also. Because we got a copy.
Actually, DC should have been a party, I think.
He was, because he was a court.
Lordship, since Lordship is
Because
expressing that
records,
thing, on 3rd, I believe,
Yes, I think so.
3/12/2024, no other than the learned Advocate General made the concession before the Honorable Court that respondent number 1, 2, and 3 are not necessary parties, that is, DC is included there. So we may be deleted. So on the basis of that submission, DC has been deleted as a party respondent. I fail to understand why my learned friend is relying his entire argument based on an affidavit who is not a party before this Honorable Court. One, yes, and I should have been served a copy of this affidavit. I have not been served with any copy till date. Why? You are not necessary party. And much time has been spent by my learned friend by relying and reading the affidavit filed by a party who is not a party in this proceeding. That speaks for itself, whether there is congruent finding of facts and law. Rulings which has been placed, but let my learned friends finish, I will give
No, I
appropriate
think it's-
reply.
You're done.
I'll adopt the submission of my. Lordship, putting one
Right.
query because of that, I stood up for the second time. What about the issue that DC passed order without hearing? So I said, report can be called for because we should not argue and we should not go against the report. Report can be called for passing the judgment. Because DC has specifically mentioned notices were issued on such a date, where the parties were called on such a date. So I cannot go beyond the report. Report can be called for passing the order. That must be fine. I cannot go beyond the report. I can repeatedly say.
No, but those things are not before the court now. What you're stating now, that was, you are relying on the affidavit of the DC.
We have received copy. Yes. So if I may be allowed to read. Otherwise, report can be called for.
They are not party now. So
Yes. Because after filing affidavit, they were dropped. After filing affidavit, they were dropped. Yes.
court reports, trial court reports were not called, no?
No,
it is there.
If it is
Oh,
there,
it
then
has
it-
arrived. It is there.
Yeah, then report will speak. But later
Those are
on, that
reports
may
are
be
there.
called for.
DC reports are there. Oh, yes, it's here.
Then that's very
It's
good.
here.
Then
Order has been passed by
Yes,
this
yes,
court.
yes.
Then there is no argument. Then
Yes.
May I please, my lord?
Yes.
My lord, I am representing the village council. My lord, here, presently I am respondent number 1, my lord. This is my village council, my lord. As you are aware, my lord, village council is a judicial court. As per Nagaland Village Council Act, as well as Administration of Justice and Police in Nagaland, my lord. Here, village council have passed.
Actually, no, village council, there's nothing much to say. Because it is a court, so.
Good or bad?
My lord, I just
Anyway, we will report your presence. Your name?
B. Soto, my lord.
Yes, what are you saying?
If please, my lord, I will just read 2 paragraphs of my affidavit, my lord.
Yes.
Paragraph 3. That I say that after the receipt of the record number so and so dated 27/4/22, referred by the Deputy Commissioner to the Village Council, I being the chairman and perused the said record, and on its bare perusal came to know that the Zikr clan, which is one of the clan amongst the 9 clans of the Zere Khel, had initiated a case against the Teneswele clan before Zere Khel Panchayat itself. And the said Panchayat had summoned both the parties and asked them to submit their written statement, and after perusal of the said statement, they decided to visit the spot, and only after their spot verification formed an opinion that as the Teneswele clan had already given their land to the Zere Khel community, and as the said land was belonging to the Zere Khel community itself, so the Zere Khel Panchayat had held that as it is the Zere Khel community land, so the Zikr clan, being the member of it, has no right to agitate upon it, for the land being not the individual land of Zikr clan, rather it is the community's land of the Zere Khel community. Be that as it may, I being the chairman of Visima Village Council, convened a council's meeting and took up the case and issued notice to both the parties, and who after their appearances and tendering of their statements were heard on various dates, and based upon their hearing, the Visima Village Council passed its order on 15/9/22, whereby holding inter alia that the disputed area belonged to the Zere Khel, in which Zikr clan has also a share in it among 9 clans of the Khel. It would not be out of place to state here that the decision of the village council is no doubt is akin to and in consonance with the decision of the Zere Khel Panchayat given on 27 to 19, for the reason that the Neswele clan had already given the land to the Zere Khel community, and hence the decision, according to me, is not perverse, but valid and genuine in the eye of law. Para 4, my lord. That the Visema Village Council is a village court, as defined under the Nagaland Village and Tribal Council Act 1978, read with the rules of the administration of justice and police in Nagaland, and as such, the Visema Village Council, being a court in the eye of law, would not to have been made party in the civil revision application number 12 of 24 before this honorable court. Therefore, my lord, my humble submission is to drop the Visema Village Council from the area of parties in this case and dismiss the revision petition as not maintainable and uphold the validity and fairness of the Village Council decision dated 15/9/22. Much obliged, my lord.
Yes, any reply?
I have a short reply, Lordship. I will not cross for it. And I believe my reply will be very, very important because a lot of facts have been projected. I feel it not that relevant in a writ under Article 227. We are seeking for a writ of certiorari under Article 227. Therefore, going into all this nitty-gritty under facts will not be relevant. There may be certain facts which will have a bearing on the exercise of jurisdiction by the courts. That is one. My learned friend has referred to the order of the Zere Khel Panchayat that we have not challenged that. That is not correct. In page 40, the judgment is there. In page 43, Lordship will find we've challenged that before the village court also. That is, so that is not correct. That it's not that we have not challenged. We have taken the matter to the village court. And then second submission was by referring to Rule 24 and 31 of the Rules for Administration of Justice and Police in Nagaland, a conjoined reading. Both the provisions, Lordship is well aware, exercises different jurisdiction. Rule 23, 24, 25 are original jurisdiction, and Rule 31 is the power of appeal, appellate court. Therefore, it can never go together. So that concept is also misconceived, Lordship. The next point which my learned friend has referred to, that SDO civil Jakhama do not have the original jurisdiction. On that point, Lordship, this will also be, because by referring to so many parties, I was not made party, he were not made party, SDO civil proceeding before the SDO civil Jakhama has been quashed and set aside.
Yes, quashed as such.
So what is the point of this? Who was a party, I was not party?
That one is no more there.
Irrelevant. Quash. Means gone. Under the Brahmaputra bridge, everything has been thrown away. There is nothing left. Therefore, unnecessarily we have spent so much of time. And Lordship will find at page 190, a fresh trial has been commenced at page 190 of civil revision. See, so by issuing summons 14 November 2022 by the STO civil, fresh trial has been started. So the text is clear and a fresh trial has been initiated. Now, the next point is on the issue of jurisdiction. By interrupting the submission of my learned friend, I have referred in the midst of his submission that I was explaining about the two verification. So there are two verification. One is by the village council, and the other is on the basis of the deputy commissioner. Now, based on the direction of the DC, out of the two, the one which was conducted under direction of the deputy commissioner, which was led by the STO Civil Jakama, and the village council also joined. We were not invited to participate in that spot verification, and the imbued order passed by the DC is based on that spot verification. Therefore, the spot verification conducted by the village council becomes irrelevant so as to decide this present imbued order, because order was based on the verification of the second one, where we were not invited as party respondent. Where we were not made party, basing on that the order was passed by the DC. Therefore, the opportunity of being heard, the fair play in action, has been violated. Now, my learned friend has taken a lot of time by editing the affidavit of the deputy commissioner. As I was mentioning and pointing out, on 3rd December 2024, the learned additional advocate general has made a concession before his honorable court that respondent number 1, 2, and 3 have been made have been made as party, but they are not necessary party. On the basis of that submission, they were deleted as party respondent. Therefore, the question is whether we cannot rely on an affidavit who is not a party before this honorable court. And very interestingly, no copy has been served to us, that affidavit. No copy served. Even admitting the fact that they are not a party respondent, no copy has been served on us. The affidavit, the so-called affidavit filed by Deputy Commissioner, but the fact remains that they are no longer a party in this proceeding. That is very clear, Lordship. So, on the basis of a party affidavit filed by a party who is not before this honorable court, whether this honorable court can give credence and cognizance to that. In my submission, it can be certainly not. The next point, Lordship.
No, that point was only to show whether the parties were all heard or not. So for that he was referring, because the DC's affidavit said that all parties were heard. So only on that point. But for that, the court will go through the
I have already submitted that, yes, we were also called, someone, and heard. But the fact remains that even there was a proceeding before the STO Civil in connection with this, and all the statements were given before the STO Civil. It was a formal showbiz before the Deputy Commissioner. Now, all the parties have filed affidavit in response to the revision petition. The statements which we have made in the revision petition, they have not refuted or denied anything. Yes, no doubt, they have said whatever they wanted to say. But the statements which we have made in the revision petition has not been refuted and categorically denied. Not even a single paragraph has been denied by all the respondents. That is very important. Another point which is very, very vital is the GP Mills Order of 1925. Lordship has put the categorical query to the Council of the respondents, particularly respondent number 2. My learned friend neither said yes or no, but I do not know. And in the revision petition, we have made categorical statement that this order is non-existent. In clear terms, we have mentioned that. Before the village council also, we said that Even by approaching this Honorable Court in the pleadings, we have clearly mentioned about this because our grievance is on that. They have not produced even before this Honorable Court. After we made categorical statement that this document is not in existence, if at all there is any, that should be exhibited in the form of an evidence. That was not done. They may have manufactured or fabricated, but that was not used as an evidence before the court, the trial court. And in spite of the specific pleading before this Honorable Court also, there is no statement on that. When this Honorable Court made a query in the course of hearing, my learned friend also said, I don't know. So Lordship is very well aware that in law, the commonly accepted principle is silence amounts to admission. So since my learned friend do not have any positive answer to that, rather express ignorance about this order. Therefore, the non-existence of this document is admitted by the respondents. Now, while referring to the judgment of the village council, next point, my learned friend has referred to an order of the village council, that is page 185, the signature portion. It starts from 183 and it culminates in the signature of all the parties starting from page 185, the session. Kindly see. Of course, these are records. On the left-hand side, in the column signature, in the bottom, Zasi Vol Vitsa, GV Besima Village. No signature. And in the next page, 186. Number 8, Vaza Chaya, JV Vesima Village. No signature. And then after leaving one, serial number 12, Payment 12 KK, Chairman K. Khel Panchayat Vesima Village. This is the chairman of K. Khel. No signature. Serial number 14, Pole Kizo, Secretary P. Khel Panchayat Vesima Village. No signature. And under right column, serial number 9, Mane Doso, GV, Vesima Village, no signature. Serial number 11, Poto Kiso, Chairman, P. Khel Panchayat, Vesima Village, no signature. Serial number 15, on the bottom, Metil Vetsa, Secretary, K. Khel Panchayat, Vesima Village, no signature. Why no signature? Because these are the people, 7 people. They said, since it is not proper and not correct, we will not put our signature. So they have not signed. It is on record. And the Deputy Commissioner has relied on this judgment. And my learned friend in the course of summation has supported this judgment, that there is no material irregularity. Lordship is well aware that any judgment should be signed by the parties. So their signature is not there. What more material irregularity than this? Non-existence of GP Mills Order of 1925, non-execution, non-signature by the members of 7 persons in the village council who are GBs and responsible people, who are GBs and the chairman of respective KELs. They have not put their signature.
What do you say about the gift deed? Because village council as well as DC
We were
has
not knowing
relied
about
on
this.
one gift deed.
We were not knowing about this. Had we knew it from before, we could have taken appropriate steps also.
My lord,
No.
small interruption. That is part of the annexure. In present case.
In the present case
In the
only.
present case, yes.
They have annexed, not me.
After the proceeding was initiated before the Deputy Commissioner, this was brought in. Now, to conclude, my learned friend has
Too many
met
disputed facts.
submission. That is why
Yes.
it is a revision petition. Knowing all these facts, initially in the initial part of my argument, I have also said that there is a checkered history of litigation.
Yes.
Let me simplify. We are not required to go into all these disputed questions. If we are to go into it, there may be so many things which can be ticked out also, which will not be relevant to decide this revision petition. So, we are confining only to the exercise of jurisdiction by this Honorable Court, whether there is material irregularity or not, so as to maintain a revision petition. So, on the basis of the submission, in the course of the proceeding, what type of a proceeding was conducted, Lordship has seen. Therefore, what more material irregularity when the judges have not signed in the order, when the order is based on a non-existent order, it was not exhibited also. So, all these material irregularities demands that the order of the Deputy Commissioner is required to be interfered with. And as I was pointing out from the initial stage, that the initial part of the order sequence starts from 1/7/2022, passed by the Deputy Commissioner, which was an ex parte order, and then sent back to the Deputy Village Council. Village Council has sent to the, against the Village Council order, it came to DC. And we were not given a fair hearing, and the materials available on record were ignored and given the decision based on the decision of the Village Council, where 7 members of the court has not signed in the order. So the rulings, when facts and law corroborates, then it should not be interfered. Here is a case where facts says something and laws says something. So I have referred to Rule 31 also, how the DC should exercise the jurisdiction. So the DC has committed gross and grave illegality in deciding the case. Therefore, the 3 imbued orders of the Deputy Commissioner, which includes ex parte and the present imbued order, should be set aside and quashed. And if any party is aggrieved, then they should be given liberty to approach the appropriate civil court. It may be D, it may be mine also. DC has already decided the title without having any evidence and based on a non-existent order. Therefore, the imbued orders has to go and let there be a fair and fresh trial in accordance with law. I apply, Your Lordship. Since I have given the assurance to complete it before 4,
Yes.
I believe
Yes,
I have given
you
my
have-
words.
You have kept your word.
Yes.
Acha, you give photocopies of that judgment also, okay? Who's that? You do first one. Where is that? No, this is one, then the other one.
Book.
That book?
Yes.
No, not this. Not this.
Yeah,
I think you have taken back it.
No, we have not taken it.
Learned friend can furnish a Xerox copy after the proceeding also.
Yeah.
It's okay.
Court, we can give from library.
It is your cost.
You give me only the photocopy. Lieutenant Counsel for the petitioner, Mr. City Jamir, Senior Counsel, Mr. City Jamir, assisted by
I am Chen.
Also heard Mr. Ashik Rizal for the respondent number 2, Mr. W. Mar for the respondent number 3, and Mr. P. Soto for the respondent number 1. Judgment is reserved.
Mazur.